Well, my friends, welcome to Uncivil Law, and the day we have waited for is finally here. I am afraid it is, in fact, not a joke. It may be April 1st, but the Karen Read trial is actually really starting for reals. I know. It's all happening. And we turn our attention to the courtroom where things are already underway. Judge Bev taking the stand, apologize to the bench. Very exciting. I'm excited. You're excited. It is 9:33 on the East Coast. Holla, at least according to the clock.
All persons have any business before the Honorable Beverly Cannoni, Justice of the Norfolk Superior Court, and for the County of Norfolk. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts.
One of two things is true. Either that clock is off or they're not broadcasting live. One of the two things, because I'm only a minute behind. So the clock is wrong.
Court is now open. You may be seated. Jurors remain standing. Everyone else may be seated.
I'm sorry, jurors. Could I have you all raise your right hands, please? Do each of you solemnly swear to make true answers to such questions as should be put forth to you by the court, so help you God? Thank you. You can have a seat now, I promise. May I call the case, Your Honor?
Yes.
Your Honor, this is 22-117, the Commonwealth versus Karen Read.
Counsel.
You want counsel? Or do you want me to say?
Counsel.
Could I have counsel identify themselves for the record, starting with the Commonwealth?
Good morning, Your Honor. Laura McLaughlin for the Commonwealth.
Good morning, Ms. McLaughlin.
I'm Lally for the Commonwealth. Good morning, Your Honor.
Good morning, Mr. Lally.
Good morning, Your Honor. Hank Brennan for the Commonwealth.
Good morning, Mr. Brennan.
Good morning, Your Honor. Alan Jackson on behalf of Karen Read.
Good morning, Mr. Jackson.
Good morning, Your Honor. Elizabeth Little, also on behalf of Ms. Read.
Good morning, Ms. Little.
Morning, Your Honor. Robert Alessi on behalf of Ms. Read.
Morning, Mr. Alessi.
Good morning, Your
Holla.
Honor. David Yannetti for Karen Read.
Good morning, Mr. Yannetti.
Good morning, Your Honor. Victoria George on behalf of Ms. Read.
Good morning, Ms. George. Good morning, Ms.
Victoria!
Okay.
Victoria's there. Holla, Victoria. Glad to have you be part of the party.
To be tried, and these good men and women who I shall call to pass between the Commonwealth and you upon your
Victoria
trial.
is the former
If you object
juror.
to any of them, you must do so before they are sworn.
Once
You
was a
must
juror,
object to
now
16
represents Miss Read.
Thank you.
Juror by day, attorney by night.
Okay. Good morning, jurors. My name is Beverly Cannoni. I'm a judge of this court, and I want to welcome you here today and give you some idea on what you will
We are
be
definitely
asked
going
to
to
do.
fangirl Victoria a little bit during this trial. I'll
Jury
tell you what,
service,
man.
as you know, is one of the most important duties we have as citizens. We appreciate that you're here, ready, willing, and able to serve if you're called upon to do so, and our system of justice simply does not work without you.
They are
So
not broadcasting juror selection. No, they're
This
just
is the case
broadcasting
of
the initial
Commonwealth versus
instructions.
Karen Read.
So it's going to be a short
The
stream.
Commonwealth alleges that at approximately 6 a.m. on the morning of January 29, 2022, the Canton Police Department received a 911 call reporting an unresponsive male party in the snow outside a residence at 34 Fairview Road in that town. Officers responded and discovered the man, later identified as John O'Keefe, off the roadway in the front lawn area. Officers identified 3 women with Mr. O'Keefe, one of whom was the defendant, Karen Read, the girlfriend of Mr. O'Keefe. The defendant had been with Mr. O'Keefe the previous evening at 2 different bars in Canton and had driven with him to this residence in the early morning hours of this date. Mr. O'Keefe was treated by paramedics from the Canton Fire Department and transported to the Good Samaritan Medical Center, where he was subsequently pronounced deceased. The Commonwealth alleges that the defendant struck Mr. O'Keefe with her vehicle earlier that morning and then left the scene while Mr. O'Keefe lay injured in the snow during a blizzard. The defendant denies these allegations. She is presumed to be innocent and has pled not guilty. So Ms. Read is charged with second-degree murder. She is also charged with manslaughter while operating under the influence and with leaving the scene after causing personal injury or death. I will describe these indictments in detail at the end of the case when I teach you the law, but briefly, murder is the unlawful killing of a human being. There are various ways in which the Commonwealth can prove a murder case, and the Commonwealth is permitted to proceed under all theories it believes it can prove. Here, the Commonwealth alleges that the defendant committed murder and that the murder was murder in the second degree. In order to prove the defendant guilty of second-degree murder, the Commonwealth must prove beyond a reasonable doubt that the defendant committed an unlawful killing and that it was done with malice. In comparison, involuntary manslaughter is an unintentional, unlawful killing caused by wanton or reckless conduct. These terms and the elements of the crimes will be explained to you in greater detail at the end of the case before you begin your deliberations. Now, at the outset, I would like to address the issue of public interest in this case and the duty of this court to adhere to the rule of law. John Adams said that we are a government of laws, not of men, and that the law must be deaf to the clamoring of the public. He meant that while the public opinion about a given subject may ebb and flow, the law must be steady, reliable, and even-handed. We know
That's
that
what
on
it's
the
supposed to
subject
be.
of this case,
Yeah.
there are people advocating for one outcome or another with intensity, but without the benefit of having heard or seen any evidence at all.
I've heard and seen quite a lot of
Law works
evidence.
in a different way, and the difference is crucial to our system of justice. The jurors selected for this trial will hear and judge the evidence. They will decide what the facts are, and where the evidence is contested, they will determine where the truth lies. Ultimately, the jury will decide whether the Commonwealth has carried its burden of proving that the defendant is guilty of any crime beyond a reasonable doubt. People outside of this building have rights, and we know that they have voices, but this criminal trial will be decided by an independent jury, free from outside interference, based only upon the evidence presented in this courtroom and the law. This is the only way to ensure that every person who comes before the court receives a fair trial. It is just that simple and that important. So, while public comment will likely continue,
Likely?
the rule of law will be upheld.
I'm not sure about that second part.
order to
I'm more
determine
confident
your
about the first part
eligibility
than the
to serve
second part, to
on
be
this
honest.
case, I'm going to ask you questions, all as a group, and then I'm going to ask you to fill out a supplemental questionnaire. We have found that the use of this questionnaire is helpful for several reasons. First, there are some personal questions on it, and we ask that you be candid. In addition, the process of filling out the questionnaire provides the opportunity to be more reflective as you answer the questions, rather than being put on the spot and asked to give immediate answers. After you fill out the questionnaire, we will have you come up to the sidebar one at a time so that we can follow up with you on your answers to the
Wow, this
questionnaire
voir dire is
and
going to take a hot minute if we're really going to do it
Thank
that
you in
way.
advance
If
for
we're
your
going to bring
patience as we
each
go through this
potential juror
process.
up to the bar, this is going to take 2 weeks.
As you may know, the lawyers for the parties participate in the selection of the jury. Under our law, each of the parties has the right to exercise what we call juror challenges. This means that each party has the right to challenge a certain number of prospective jurors for any reason or for no reason at all. Therefore, some of you may be excused during the impanelment procedure. If you are not selected for jury service on this case, you should not take it personally. Don't think that somehow you're not a fair person, because it's not a reflection on you at all. You will be directed back to the jury room and perhaps be picked for another case. In a few minutes, I'll pose a number of questions to you as a group. You have just taken an oath that requires you to truthfully answer these questions and all questions posed to you. If your answer to any question is yes, I will ask that you raise your hand and hold up your juror card in the air with the numbers facing out so that the court officer can read the number from the card. You don't have to get your cards out yet. I'll tell you when it's time to get your cards out. Now, the fact that you answer yes to one of my questions does not mean that you're automatically disqualified from jury service. It simply means that there are matters that counsel and I must discuss with you. If you find a question posed to the group overly intrusive, you may elect to answer the question at sidebar. I may have additional questions for you which relate to issues that may be raised in the trial.
Is this one of those courthouses that has a bar near it called sidebar? Because I really need that to exist in my life at this particular trial.
Permitted to ask you questions for the same reason. This is not a test. There is no right or wrong answer.
There are
to
definitely
any
some wrong
question.
answers.
We're simply looking for your honest and best answers to the questions. Now I'm going to have the lawyers introduce themselves. We'll start with the Commonwealth, and when the defense introduces themselves, please introduce your client. Mr. Brennan,
Your Honor.
please.
Thank you. Good morning, ladies and gentlemen. My name is Hank Brennan. I represent the Commonwealth of Massachusetts.
You sure do.
Me and two other attorneys I'd like to introduce you to. All the way to my right is attorney Laura McLaughlin.
Laura doesn't look like she really wants to be there.
This is her attorney Adam Lowry.
Thank you. Defense counsel,
Laura,
please.
blink twice if you need help.
Good morning, ladies and gentlemen. My name is Alan Jackson. I have the privilege of representing Ms. Karen Reed, who is to my right.
Good morning, members of the jury. My name is Elizabeth Little, and I also have the privilege of representing Ms. Reed.
Good morning, ladies and gentlemen of the jury. My name is Robert Alessi, and I also have the privilege of representing Ms. Reed.
Good morning, ladies and gentlemen. My name is David Yannetti. I'm an attorney. I have an office in Boston. I also have an office in Dedham. It's my privilege to represent Karen Reed.
Good morning, members of the jury. My name is Victoria George, and I have the pleasure.
Victoria! 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 Ooh, 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 Victoria!
Folks, I'm going to read a very lengthy witness list to you. It's important that you listen to the names because at some point I'm going to ask you whether you know any of these folks. So when you hear it, please listen to it in those terms. Now, it does not mean that all 150 witnesses are going to be called at trial, but you'll hear their names if they're not called. You may hear their names during trial. So it's important that we know if you know these folks. The list is alphabetical, but it's alphabetical by first name. So Aidan Kearney from Jefferson, Mass.
Aiden!
Dr. Aziz Wolf from South Miami, Florida. Alfredo Lopelato from Canton. Allison McCabe, also Canton. Andre Porto from the Massachusetts State Police Crime Lab.
Aiden is
Andrew
first
Klain
in
from
name,
Bridgewater.
first in our hearts.
Andrew
Lol.
Rentschler, PhD from Pittsburgh. Angela Malvone from Canton. Annie Chung from Canton. Anthony Flamati from the Canton Fire Department. Ashley Bell from Canton. Ashley Valliere from the Massachusetts State Police Crime Lab. Brian Albert from Norwood. Brian Albert Jr. from Boston. Brian Higgins from Sandwich. Brian Loughran from
Sandwich?
Canton. Brian Wanless, retired Canton Police Department. Bridget Meehan, Keeper of the Records. in
Keeper of the
Canton.
Records. This is a nice title.
Caitlin Albert
I like
from
that title.
Easton.
Keeper of the Records.
Charles Ray, a
That sounds
lieutenant
like
with
some
the
sort of
Canton
Monty
Police
Python-esque
Department.
shit.
Chief of Police of Canton, Helena Rafferty.
Mr.
Chris
Jones,
Van
Keeper
Lee,
of the
PhD
Records.
from Novi, Michigan.
Mr. Smith, the
Christina Hanley from the Massachusetts State Police. Christopher Albert, Canton. Christopher Curran, Canton. Colleen Crawford from the Norfolk County District Attorney's Office in Canton. Colin Albert from Canton. Courtney Proctor from Canton. Kurt Roberts from Canton. Daniel Whitley from the Canton Fire Department. Daniel Wolf, PhD from Penns Park, Pennsylvania. Derek Ellington from Wake Forest, North Carolina. Dr. Marie Russell from Los Angeles. Dr. Elizabeth Loposada from Providence. Elizabeth Proctor from Canton. Eric Hanlon, Canton. Erin Beatty, Canton. Erin O'Keefe, West Bridgewater. Francis Walsh from the Canton Fire Department. Darren Wing from Green Cove Springs, Florida. Gary Fowler from Brockton. Gregory Woodbury from the Canton Fire Department. Gretchen Voss, Boston, Mass. Hannah Knowles from the Massachusetts State Police Crime Lab. Heather Maxon from Walpole. Arabito Hernandez from the Boston Police Department. Holly Price from Mountain View, California. Ian Whiffen from Vienna, Virginia. Dr.
Vienna.
Scortibello.
Vienna's
from
nice.
the
Been there.
Office of the Chief Medical Examiner
there.
of Massachusetts. James Crosby, PhD, from Jacksonville, Florida. Jason Becker from the Canton Fire Department. Jean Demoulas from Canton. Jennifer McCabe, also Canton. Jessica Hyde from Bridgeport, New York. John O'Keefe.
I've been
Sr.
everywhere,
from
man. I've been
Judson
everywhere, man.
Welcher, PhD, from a company called Aperture, LLC. Julie Albert from Canton, Julie Nagel from Canton, Dr. Justin Rice from South Weymouth. There's a juvenile whose initials are KF from Canton, and there's another juvenile whose initials are PF, also from Canton.
How's that supposed to help the jurors?
Caitlin Boudreau from
Okay,
Raymond.
I understand that we don't necessarily want to use juveniles' names, but if the idea is, do you know these people? How are these jurors supposed to know who that person is, whether they know them or not? So how's that helpful to the jurors? It doesn't make any sense. It doesn't make any sense. Make it make sense. Carrying on.
Karina Kolakithis from Canton, Katie Camerano, also Canton, Katie McLaughlin from the Canton Fire Department, Keeper of the Records for Ring from Hawthorne,
Keeper of the
California.
records!
Kerry Curran from Canton, Kerry Roberts, Canton, Kevin Albert, Canton, Kevin O'Hara from the Massachusetts State Police, Lance Mello from the Massachusetts State Police Crime Lab, Laura Sullivan from Pembroke, Laurie Cahill from Worcester, Leslie Pearlstein from Canton, Lieutenant Michael Lank from the Canton Police Department, Louis Jutras from Canton, Lieutenant Brian Tully from the Mass State Police, Lieutenant John Fanning from the Mass State Police, Lieutenant Paul Gallagher from the Canton Police, Maggie Gaffney from Bonita Springs, Florida, Mark Lopalato, from Canton, Margaret O'Keefe from Canton, Marietta Sullivan from Pembroke.
Yeah, we're not going to see jury
Susan
selection.
Dayton,
All they're going to
Matthew
broadcast
Emery
is the
from
initial
Canton, Matthew
instructions, as I understand it.
Sobra from
So
Charlotte,
I think
North
this is the
Carolina,
only live stream
Matthew
that we're going to
Erickson
see
from
until the
Grosse Pointe Farms,
trial
Michigan,
actually starts
Matthew
in
Kelly, Canton
presumably
Fire
2
Department,
weeks.
Matthew
So this is a little
Kelch,
teaser
Federal Bureau of
stream.
Investigations, Matthew McCabe from Canton, Maureen Harnett from the Mass State Police Crime Lab, Megan Mariani from New York, New York, Michael Camerano from Canton, Michael Easter from Los Angeles, California, Michael Trotta, Canton Public Works Department, Michael Wagner from Foxborough, Mike Maroli from Bridgewater, Mike Rushworth from Thompson Station, Tennessee, Natalie Wyweek Berschneider from San Marino, California, Nathan Reed from Raynham, Nicholas Bradford from Lorton, Virginia, Nicholas Curran from West Roxbury, Nicholas Kolakithis from Canton, Nicole Albert from Norwood, Norfolk County District Attorney Michael Morrissey, Officer Kelly Deaver from the Boston Police Department, Officer Nicholas Barrows from the Dighton Police Department, Patrick Haggerty from Somerset, Paul Makowski from Melrose, Paul O'Keefe from Canton, Rebecca Bison from Canton, Rebecca Treyers from Norfolk, Mass, Dr. Renee Stonebridge from the Office of the Chief Medical Examiner's Office in Boston, Richard Green from St. Pete Beach, Florida, Richard Donatino from Canton, Robert Gilman from Hull, Ryan Nagel from Canton, Sarah Levinson from Canton, Sergeant Brian Gallerini from the Needham Police Department, Sergeant Sean Good from the Canton Police Department, Sergeant Paul Giampietro from the Canton Police Department, Sergeant Yuri
So I thought this was supposed to be
Buchanan
alphabetical
from
order, but we seem to be
Massachusetts
moving
State
up and
Police,
down the alphabet.
Shannon Burgess from South Lake,
Wait, no, we were at G and now we're back to B.
Cheryl Waugh from Canton, Sophie Herzan from the Mass State Police Crime Lab, Stephanie Devlin from the Mass State
Wait,
Police
D?
Crime Lab.
I thought it was
Stephen
supposed to be
Laney from the
alphabetical.
Canton
I don't
Police
understand.
Department, Steve Nelson from the Norfolk DA's office, Steve Bernstein, who is a keeper of the records in Stoughton, Stephen Ridge from the Boston Police Department, Stephen Seraph from the Canton Police Department, Stephen Scanlon from
It's
West
alphabetical by
Roxbury,
first name.
Terry Kuhn from Davis, California.
Who does alphabetical by
Tess
first
Hart from
name?
Norton, Virginia. Thomas Beatty, Canton.
Who does
Thomas
that?
Kelleher, Canton. Thomas Martin, Weymouth. Timothy Nuttall from the Canton Fire Department. Tristan Morris from Easton. Trooper Connor Key for the Mass State Police, also from the Mass State Police. Trooper David DeChico.
No, it's not
Trooper
alphabetical by
Evan
first
Brett,
order.
Trooper Jeffrey Kostowski.
Because
Trooper
it said
Joseph
D,
Paul,
right?
Trooper
It's not
Kathleen
even
Prince,
alphabetical by
Trooper
first
Michael
name.
Proctor, Trooper Nicholas
There's Proctor.
Ingram, Trooper Zachary Clark. Wendell Robery from Canton, William Reed from North Dighton. That's the list of witnesses.
I think the
folks.
alphabet might be
You know what,
different in
I'm going to
Massachusetts
ask
than
you
I
all
remembered.
If you know any of those folks. So As you can imagine, this case is expected to take a while. The lawyers tell me that once we get a jury, which
Trooper
may also
starts with
take a
T.
while, once we get a jury, that it's estimated that the evidence in this case should take 6 to 8 weeks. We do our best to let you know in advance what we anticipate the length of trial will be.
Trooper is their first
When we
name.
start the trial, we will go full days so that we can expedite the trial. The dates that I'm giving you, the 6 to 8 weeks, is the far end of what we expect this to be, just for planning purposes. So the days will begin at 9 o'clock. We'll take a recess at about 11 for 15 or 20 minutes. We'll go until 1. Lunch will be brought into you. We'll start up sometime around 2 and go till 4 o'clock. Or 4:30 every day. And there'll be days off here and there throughout the schedule, and perhaps half days throughout the schedule.
Half
So that's the
days.
schedule that we intend to keep. Now, it might help you if I give you a preview right now about some basic law that applies to criminal cases like this. It's my job to teach the jury the law, and I don't do that completely until the end of the trial. So for now, I'll give you a very brief summary of some of the legal principles that govern the trial. First, and most basically, the defendant starts this trial presumed to be innocent. The fact that she was arrested or that she was indicted is not proof of anything. An indictment is just a piece of paper. It just makes an accusation. An indictment is merely a formal manner of accusing a person of a crime in order to bring her to trial in the superior court. But it is only the jury, in other words, you folks, who can decide whether the prosecution has proved its case beyond a reasonable doubt. If the Commonwealth does not do that, then the presumption of innocence requires you to find the defendant not guilty. The law does not require a defendant to prove her innocence, to produce any evidence whatsoever, or to do anything other than attend the trial. This presumption of innocence remains with the defendant until you, the jury, make your determination after listening and considering all the evidence. Another important principle of law is that the defendant has an absolute right not to testify, since the entire burden of proof in this case is on the Commonwealth to prove that she is guilty. Under our system of law, a defendant has a perfect right to say to the Commonwealth, "You accuse me, now you prove it, and prove it beyond a reasonable doubt. I do not have to say a word." A defendant's decision whether or not to testify has nothing to do with the question of whether she is guilty or not guilty. The jury must not consider it in any way or even discuss it in their deliberations. Jurors in a criminal case must determine whether the Commonwealth has proved its case against the defendant beyond a reasonable doubt based solely on the testimony.
That's what they're
of the
supposed to
witnesses and the
do.
exhibits.
But then again, Karen Reed was there, John O'Keefe was
That brings me
there,
to the
therefore Karen
requirement
Reed did
of
it.
beyond a reasonable doubt. What is proof beyond a reasonable doubt? The term is often used and probably pretty well understood, though it is not easily defined. Proof beyond a reasonable doubt does not mean proof beyond all possible doubt. For everything in the lives of human beings is open to some possible or imaginary doubt. A charge is proved beyond a reasonable doubt if, after you have compared and considered all the evidence, you have in your minds an abiding conviction to a moral certainty that the charge is true. When we refer to moral certainty, we mean the highest degree of certainty possible in matters relating to human affairs based solely on the evidence that has been put before the jury in this case. I have told you that every person is presumed to be innocent unless and until he or she is proved guilty, and that the burden of proof is on the Commonwealth. If you evaluate all the evidence and you still have a reasonable doubt remaining, the defendant is entitled to the benefit of that doubt and must be acquitted. It is not enough for the Commonwealth to establish a probability, even a strong probability, that the defendant is more likely to be guilty than not guilty. That is not enough. Instead, the evidence must convince you of the defendant's guilt to a reasonable and moral certainty, a certainty that convinces your understanding and satisfies your reason and judgment as jurors who are sworn to act conscientiously on the evidence. This is what we mean by proof beyond a reasonable doubt. A juror's job is to find the facts. In determining the facts, you may draw reasonable inferences from the evidence that you believe because you're entitled to rely upon both direct and circumstantial evidence. I'll define those terms in greater detail later, but Direct evidence essentially is evidence of what a witness claims to have seen or heard or touched or somehow perceived with his or her own senses. Circumstantial evidence exists where a witness does not testify directly to the fact that is sought to be proven.
Imaginary evidence is collected in solo cups.
And then asked to draw reasonable inferences from them about the fact that is sought to be proved. Jurors are entitled to consider both kinds of evidence. There is no difference at all in the probative value between direct and circumstantial evidence. Circumstantial evidence is competent to establish guilt beyond a reasonable doubt. Now, I've used the word inference. An inference is a logical deduction or conclusion that you may, but are not required, to draw from evidence that you have accepted as believable.
Red Solo
Inferences are
Cup,
little steps in reasoning.
I'll
steps
fill
on which
you
take
up.
some known
Let's have a
information, apply your
trial.
experience in life to it, and then draw a conclusion. An inference drawn from circumstantial evidence need not be necessary or inescapable, but any inference which you do draw must be reasonable and possible. It must be logical. It must be a natural one which is not too remote in the ordinary course of events. You may not guess, you may not speculate or engage in surmise. When the evidence tends equally
Is
to
it
give
weird the
rise
defense
to
sits
either
behind the
of two
prosecution? It's a little
inconsistent
weird
propositions, the
how this
Commonwealth has
courtroom is set
established
up.
another proposition. In order to convict
But, you know, I
the
think
defendant, you must find
I
that
think I might like
all
it
of
better than the
evidence and
alternative.
reasonable
Because normally it's
inferences that
side
you
by
withdraw
side and
taken
they're
together
sitting closer to
prove
the
that she is
jury.
guilty beyond a
So-
reasonable doubt.
It's weird, but it is what it is.
Now, our system of justice depends on judges like me and jurors like you being able and willing to make careful and fair decisions. All people deserve fair and equal treatment in our system of justice.
Yeah, we need a red Solo Cup
regardless of
emoji.
their race,
Let me see if I
national
can find a
origin,
red Solo Cup
religion,
emoji and
age,
add it to the
ability,
list.
Gender,
That's fair.
sexual
Hold
orientation,
on. Let me see what I can do.
income level, or any other personal characteristic. You have agreed to be fair, and I'm sure that you want to be fair, but that is not always easy. One difficulty comes from our own built-in expectations and assumptions. They exist even if we are not aware of them, and even if we believe we do not have them. Some of you may have heard this called implicit bias, and that is what I'm talking about. We judges have the same problem, obviously, as everyone else.
Yes,
So
you do.
Let me share a few strategies that we have found useful. First, slow down. Do not rush to a decision. Hasty decisions are more likely to reflect stereotypes or hidden biases. Second, keep an open mind. Avoid drawing conclusions until the end of the case when you and your fellow jurors deliberate. Remember that when you deliberate, you will have all the evidence and all the time you need to make a careful decision. So there truly is no need to stop making up your mind before then. Third, you should listen closely to all the witnesses. That is the best way to ensure that you decide this case based on the evidence and the law instead of on unsupported assumptions. Fourth, as you listen to the testimony about the people involved in this case, consider them as individuals rather than as members of a particular group. Finally, I might ask myself, would I view the evidence differently if the people were from different groups, such as different racial, ethnic, or gender identity groups?
Okay. Yep.
At the end of the case, I will remind you of these strategies and ask you to focus on the evidence instead of any unsupported assumptions you may have. All we ask is that you individually and as a group do your best to resolve this case based upon the evidence and law, without sympathy, bias, or prejudice, to the best of your ability as human beings. Now, I know that some of this may be confusing, and perhaps all of it's confusing at this early stage of the case.
It's pretty confusing.
You'll certainly be in a better position to understand this at the end of the case when you've heard all the evidence and I can explain the law in detail. So don't be worried if you didn't catch everything I
Yeah,
said.
we got Solo Cups now, baby.
Why am I
We got
telling you
Solo
these things
Cups.
now? Because we need
got
to
Solo
know if
Cup
you're
emojis,
able to
baby.
follow the law in this case. You don't necessarily have to agree with the law, but all the jurors will have to apply the law as I describe it. So for jury selection, it's important to know if any of you might have doubts whether you can accept and follow these legal rules. So I'm going to ask you questions in a few minutes. So if your answer is yes to any of my questions, please raise your hand. Before we begin, though, I understand that sometimes jurors do not fill out the juror questionnaires completely, that sometimes we are in a rush to send them in, or sometimes we don't think that our situation applies to the question that is asked. If the lawyers and I notice that the questionnaire appears to be incomplete, we may ask you to answer the question for us. Also, if you know now that you failed to include information on the questionnaire, for example, a work history, prior involvement with the court, whether as a party in a case, a witness, or a juror, please let us know. So while you're taking out your cards, I will see counsel and Chief Rosen, juror number 79, too, and counsel at sidebar, please.
Sidebar. Sidebar. So we're doing a little Q&A. We're doing some questions right now in the chat room. Or apologize on the jury selection. They can't. What shall we focus on? Let's focus on this corner of a desk. And we're focusing on this woman's purse. The purse is the most interesting thing, I guess. Well, yeah, or maybe that's not even, maybe it's a satchel. I'm not sure if it's a purse or a satchel. Satchel gate. Exciting. Do you have to be a member to get the solo cup? You sure do. Yes, the emojis are only available to members. It's one of the membership benefits. You get some cool emojis, and we'll create some more, I'm sure. End screen, custom, text, end screen, custom, text, and custom. Well, that's really great. Boston 25 there. Way to go there with your end screen custom. Lol. Yeah, so anyways, as we discussed earlier, they are not broadcasting the actual jury selection. So I think all they're broadcasting is this generalized instruction, if I understood the media order earlier, because it was contained in the media order, I'm pretty sure, because I remember reading it. So they weren't going to be broadcasting the individual Q&A, which is just as well, because I find it like pulling teeth, to be honest. And so I think this might be the only thing that's broadcast, unless, of course, they do this for other groups. And I'm not necessarily sure we'll necessarily live stream that, because why would we? It would be the exact same thing, 2 or 3 other times. But maybe we will, depending on, how much notice we have that it's happening, because we don't necessarily know even when it's going to occur. Because, when that will occur will be dependent on, how long it takes for each group and so forth and so on. So exciting. In any event, welcome back to the Karen Reed trial, my friends. It feels like it has been a year. Well, it feels like it's been a year. And now we're back for part 2, Electric Boogaloo. In fact, I'm going to change the title of this stream. And I don't know whether or not I'm going to make this a thing or whether I'll change it back. But yeah, trial.
So now I have
Part
questions that I'm going to ask you, and the court officers will
Electric
read
Boogaloo.
you have that card, and hold it high, please. Do any of you folks or a close personal friend or family member know, or have you had any prior dealings with any of the witnesses whose names I've read? Please raise your hand.
96, 96, 32.
Yeah, okay, yep, so, yep.
59,
There we go. Back to the thing.
Number 83, 83.
Juror number 46, 46.
Juror number 90.
All right, thank you. Do any of you folks or a close personal friend or family member know, or have you had any prior dealings with the lawyers in this case or with the Norfolk County District Attorney's Office? I see no affirmative responses. Do any of you folks or a close personal friend or family member have any financial or other personal interest whatsoever in this case or its outcome? I see no affirmative responses. Has anyone seen, heard, or talked about this case? Please raise your hand.
Juror number 47.
I've seen, heard, and talked about this case a lot. I have thoughts.
5, 4. Juror number 4.
I'd like to think they're reasonably well-informed thoughts.
Juror number 95.
I have some notes for you, Your Honor, if you're interested. Lol.
Juror number 35. 5. Juror number 2. Juror number 107. 107. Juror number 41.
Also, we need to find even like more things to put on the display behind me. I found some of the graphics that I like. I found a couple different graphics to put on the display behind me. So it switches between the YouTube thing and switches between animations, which I kind of find fun. We need to find more animations that we can put on the thing behind me to make it even more fun. But yeah.
Juror number 90. 90. Juror number 92. 92. Juror number 91.
What grade would I give Judge Bev? Yeah, I'd have to think about that one.
Juror number 68. Juror number
D. See me after class.
Juror number 105.
Yeah, D sounds about right. See me after class. Needs improvement.
15. 115. Juror number 76. Juror number 66. Juror number 85.
Juror number 57, 57. Juror number 6. Juror number 96, 96. Juror 109. Juror 113, 13. Juror 73, 73. Juror 30.
Oh, by the way, as I sort of mentioned yesterday, just incidentally, in case anyone cares about such things, I pulled the trigger, as it were, and I bought all the things I need to make my first watch. So I bought all the things from China, and so they will arrive in, probably 3 weeks or something. So something to look forward to. I'm going to make my first watch, and then I will sell it, and we'll see if anyone wants to buy it. But I went with this purple sort of dial, black hands, and then I've got a bezel with purple markers on it, sapphire crystal with a cyclops so it's easier to read the date, an H35 automatic movement. Should be good. Should be good for a first watch. And then if that goes well, I think the second one I'm going to make is some sort of skeletonized dial. Also, by the way, I'm happy to announce that I also ordered metal stickers that say B-Fish, so that I can label the watches as being made by the B-Fish Watch Company. The B-Fish Watch Company is now in operation. Exciting. Our first product to hit the store soon.
Juror number 18, juror number 67, juror number 37, juror number 69, juror number 63, and juror number 22.
If I could replace Aunt Bev with another judge, how about the judge that was just doing the hearing the other day in this case? The one with respect to the restraining orders and stuff like that, the protective orders. How about that judge? That judge seemed pretty good. We'll get that guy.
If so, please raise your hand.
Yes. Which should be a solo cup, leaf blower, paper grocery bag. I love it. That's very good, Mel. I like this. I like this suggestion very much. Put more themes in there relating to the trial. So I won't necessarily make it exclusively that, but I'll definitely add some solo cups and some leaf blowers, some stuff. I like this plan very much. Very good. Plus 5 points to you. Plus 5 points to Gryffindor.
Number 90. 90. Number 91. Juror 106. Juror 101. Juror 105.
I also went to the nice watch store. Well, I went to the, what's it called? The Galleria in Houston. And I walked around and saw all the nice watch stores. And then I went across the street to Zadok's Jewelers, I think it's called, and looked at some nice watches that I can't possibly afford. Did I buy a kit or just parts? Mostly just parts. Mostly just parts. I didn't buy a pre-assembled kits. I just bought the individual parts. Now, to be fair, I didn't go all the way. I could have bought a case without a crystal and installed my own crystal and stuff like that. But, you know, one step at a time. Oh, and I'm also going to make both some courts and some automatics. The first one's an automatic, and I will make some quartz movements. I really want to make one using the mecha quartz movements because I think that they're just technologically badass. But I thought, you know, the NH35 seemed like a really good place to start.
Are folks aware of any bias or prejudice that you may have in regard to this case, or in favor of or against either of the parties? If you believe that you might have a bias, please raise your hand.
Yeah. And then I can find out about different movements in different cases and all kinds of stuff. It'll be fun. Where'd I get my parts? AliExpress. That seems to be where everyone gets their parts, as best as I could determine. Like I watched how I got basically started is how, you know, you get started on a lot of things. I watched a lot of YouTube channels. There's a lot of YouTube videos from people basically how to make a watch, right? There's many different videos, and they all seem to provide links to AliExpress. So AliExpress seemed like the way to go. So AliExpress is where I got my parts, and hopefully they'll arrive in 3 weeks from China. So I'm screwing a few parts together. Well, that's one way of putting it, yes.
All right, thank you.
But it's a pretty reasonable place to get
Do
started.
any of you folks have any difficulty hearing or any problem with understanding the English language, any physical or mental condition, or any religious or philosophical beliefs that would interfere with your ability to hear the evidence in this case?
I have a philosophical belief that, you know, justice and stuff.
To concentrate during the trial or to deliberate for the purpose of reaching a verdict. If so, please raise your hand.
Juror number 95, 95. Juror number 8.
Juror 101, 101. Juror number 65. Juror 105.
But in terms of screwing parts together, to be fair, even a lot of micro brands do that to some degree. Although they often have customized dials, to be fair. But yeah, even micro brands.
Would any of you folks have any difficulty following
you know,
the
and in fact, for that
concepts
matter, a lot of major
described?
companies are to some degree screwing parts together.
Entirely with the Commonwealth. Second, that burden,
you know,
of proof
until I become like Omega or
and
Rolex or something and start making my own in-house movements,
the defendant has
right?
absolutely no burden. She's presumed to be innocent unless and until the jury determines that the Commonwealth has proved its case beyond a reasonable doubt. Is there anyone who would have difficulty following those very important constitutional concepts?
Juror number 58, 58. Juror number 8.
Yeah, Rob buys kits for his pens. Yeah, exactly so.
Now, I can tell you folks that
it's a
after
reasonable
every
place to get
jury
started.
Trial, I talk to jurors, and they often tell me not only that their jury experience was an interesting one, but a rewarding one. I do understand, though, that for a few of you, however, service in this jury may be a substantial hardship, and let me explain what I mean by that. It's something more than mere.
And I will also, of course, be auctioning off some of these watches in November for the, you know,
more extraordinary.
for
It's
the
something
thing.
that
So I'll
would
be selling
justify
some and I'll
your
be
being
auctioning some,
excused and a fellow juror having to serve in your place.
you know, for
I
charity.
do understand, though, that it may be a substantial hardship. So
Yeah, you know, if it goes further, you know, we could get a mill and a router and stuff like that. Yeah, so you know, as the hobby develops,
or surgery schedule
you know,
during the course of
it seems like we're going to just kind of use off-the-shelf components,
6 to 8 weeks
and
to
then
try
as the hobby
according to the
develops,
schedule
maybe
that I've
we'll make more
described.
stuff custom.
And keep in mind that I'll only
And maybe if it
excuse
becomes
those
real,
who
maybe
have a
it'll become my
substantial
career,
hardship.
and maybe I'll start
Think you
making,
are in that
you know,
group.
everything. Who knows?
Please raise
We'll
your
see.
hand.
Juror number 97, 97. Juror number
Want to be able to try to build a grandfather clock? That'd be cool. Rob could make the case for the grandfather clock. That'd be badass. Actually, I think a grandfather clock would actually not be that hard. And in some senses, it might be a lot easier, to be honest, because the parts are a lot bigger. Well, wristwatch is probably harder if I had to guess.
Juror number 91, 106, 101, 34, 105, 70, 80, 60.
Juror 6,
There is a Grand Seiko that I have my eye on for like $5,000. I saw one yesterday that was like $9,600. I'm like, no, that's okay. But I went on the website again today, and I have my eye on one for like $5,000. So maybe if I sell enough watches, I can buy a Grand Seiko. I'm going to turn my watch hobby into making money so I can buy other watches. Yeah, Runkle can make straps. Exactly. So that's definitely in the long-term plan as well. Yeah, Runkle will definitely be making straps in the long-term plan. At least I'm not starting another coffee company. I know,
In a few
right?
minutes, I'm going to leave the bench to give you a chance to fill out the supplemental questionnaires that we have. I ask that you not talk to anyone around you or share with any other prospective juror or anyone any questions.
Yeah,
or
the jurors are raising their
comments
hand.
you may have about
They're
jury
asking
duty
questions, and juries are
generally
raising their
in
hand,
this particular
and then
case.
they'll
If
ask
you
follow-up
should have
questions
any
during the
questions or
individual
concerns,
voir
you can
dire.
raise that when you come back to talk to me. So we appreciate your patience. We understand that this will take a while, but I will recess now for you to do that. All right. Thank you.
What I get for Okay, yeah, no, okay. I do have to say I do like that clock. Okay, is the stream over now? The stream might be over. Okay, well, maybe that's the end of the stream. I'm not sure. I'm not sure what's going on there. I'll tune in and see what's going on. What happened to Madam Court Reporter? I don't know. Yeah, I don't know exactly what's happening here. But yeah, this might be all there is because, as I mentioned, they were just doing the like generalized instructions and not the individual voir dire. So that might be the end of the stream for the day. So that's okay. Yeah, recess. We'll stick on for a while we see if there's going to be more stream or what we're doing. That's fine. But yeah. Crime talk. Yeah, no one has this. We'll stay on right now. But I'll show you the stuff I got. I think this is stuff you've already seen. But I'll show you what I've got for the watch build because, you know, you might be interested. And if not, I'm going to show you anyway. Rivers versus Guerrero Supreme Court argument. I'm not familiar with that, but give me a second to do this first and then we'll go into other things. So, okay, no, my orders, nope. Okay. Yeah, so this should work fine. All right. So, okay, and I can show you sort of what the logo looks like somewhere. Hold on. There's a message or something. Message center. Okay. All right, this is going to be a little janky. All right, this is a little janky. I apologize for the slight jankiness, but that's what the logo looks like. You see how it says B-Fish there in the curliness with the capital B, capital F, B-Fish. So imagine that in, you know, a silver metal, and that's roughly what it's going to look like. So, you know, I think that's pretty cool. You know, just simple B-Fish. What's not to love? It'll be good times. Great. All right. Then in terms of what I'm doing in terms of the actual like watch. All right, I got myself just like some simple simple basic sort of hands here. So just some simple black hands, no muss, no fuss, with some green loom on them, you know, just kind of simple, clean, nothing really to write home about there, but I got those hands there. So that will be cool. And then, okay, then of course for the movement, as we mentioned before, this is the NH35 movement with the day. This is a very classic in the watchmaking community. So this is an automatic. So, you know, you move your wrist and, you know, dial powers the dial. You know, it was $31. You know, it's not the most expensive movement, but you know, it's tried and true and used in like a lot of different watches, as one would expect. It's a very tried and true. It's not necessarily particularly accurate, but it works. All right. And then, of course, all right. Then what else did I get? All right. Hold on. Is that the dial? No, that's not the dial. That's just to show the logo. It's not to show the dial. That's not the dial. I was going to try to show you the dial, but oh yeah, here. Okay, here's the dial. All right, so here's the dial I went with. I'm going with this purple dial here, and it's got this like sort of cloud texture on it. So a nice little sort of cloud, luminous sort of dial. I think, looks interesting because it's got some texture to it. So it's kind of looks fun and interesting with some simple markers. So that's fun. So then I'll have to hand apply the Beefish logo, which will be challenging at best. And there's no way I'm going to put it on straight, but we'll do our best. So that's the dial I went with. And then in terms of, the case, I went with, hold on. I have to find the right one. Which is challenging because there's so many different options. Okay, I think this is the right one. I think this is correct, but if it's not exact, don't hold me to it. But yeah, I went with this, okay, so this is just a black watch case, sapphire crystal. It's got the Cyclops, so you can read the date easier, and it's got these purple markers around it. So the purple markers of the bezel will accent the purple of the watch dial with the black hands. And that's going to be my first watch. And that case cost $31. So the actual components for the watch cost, what was that, like 31 plus 35 is 40, is 65 or 66, and then the hands or something. So it's like $70. So it's $70 of materials in the watch, and then of course I had to order things to like assemble the watch and stuff like that. I had to order some jeweler's loops so I could see closer, and some things to open the case, and some screwdrivers and stuff like that. But that stuff can be reused. So I've got like $70 in the actual watch. So like probably I'll offer it for like, 120 or 150 or something, try to make a slight profit and go from there. So I think that's going to be fun. That's sort of the working plan. And, because it's a pre-assembled case and, it's pre-made and pre-machined, it should be very good in terms of water resistance. So it should be water resistant to at least 100 meters. I don't have the ability to pressure test it, but, because it's pre-milled and everything, it should be very water resistant and very durable and all that stuff. So exciting and fun. So look forward to that. So that is the direction of things. And then, if that works out correctly, of course, then I can make other watches, and I'll make other designs and other colors and other experiments. But I went with something just kind of easy, sort of, for the moment. So that's sort of what's going on. And then, I ordered some calipers, and I ordered some, I ordered this thing, for example. This is to help you put on the watch hands, so you don't have to like just do it with your force. So this is a little plunger that this is how you put on the second hands. You see, you just push it right down, and because it's like in this press, it's a little easier. I'm also hoping that somehow I can use this press to help me put on the sticker. That would be nice if I can maybe like put some sort of like tack on it or something, and then I can put the sticker for the watch dial on, and maybe I can use that to apply the watch sticker. Maybe it will be better than me just doing it by straight hand. So I'm hoping that I can use this tool for that purpose as well. We'll see. But yeah, so all those parts are coming from China, and they'll come together, and we'll see. I ordered 2 sets of hands, incidentally, because they say there's a pretty decent chance you're going to screw it up the first time. And I also ordered some replacement watch stems, because you have to trim the stem to fit the case. And I'm like, yeah, there's a pretty decent chance I'm going to screw that up too. So I ordered some I ordered some extra watch stems in case I screw it up the first time. You know, measure twice, cut once, and I'm still probably going to screw it up. But we'll see how it goes. And you know, so I figure, you know, for the first year of doing it or so, it'd probably just be pre-made components. But I'm gonna do like the NH35 movement. I'm definitely gonna try to do some of the like the mecha quartz Seiko movements, because I just think they're really cool, because you have a quartz that has a ticking second hand. So you get like a 4 hertz movement with a quartz, which I just think is wicked cool. Technically, you get that mechanical look with a quartz accuracy, which is just like badass. But yeah, all those things. And you know, Rob and Ian can make the leather strap, and Rob can make the box, and it'll be good for charity. So I'm looking forward to all that stuff. I like having a second hand, but a lot of people don't. Yeah, you don't actually have to install the second hand, obviously. So if you didn't want to watch that had a second hand, all you have to do is just not put it on. Right? I mean, then there's no second hand. And it will be fine. You just don't put it on. So if you wanted one without a second hand, I can do that too. And also I'd ideally like to do one with like some small seconds at the 6 o'clock position. That'd be cool. Because I think that's a really cool look. When you have a little small sub dial at the 6 o'clock position that has all the seconds. I think that's a really clean look. And also ideally at some point I'd like to do a moon phase. So you can see the phase of the moon. But that seems like a more advanced project, so maybe later. I'm super loud compared to the court. Well, I should be a little bit louder compared to the court. I should be about 5 decibels louder than court, because I want to speak over the court. But you're right, probably. I probably need to boost the audio, because even though actually the court audio is actually only 5 decibels softer than me, because of the way the broadcast, my voice probably sounds a lot louder. So it's actually not technically louder, it just sounds louder. But I can fix that problem, and I just need to boost the audio so that problem will be diminished. But thank you for the future. I'll make sure to boost the audio so that problem is diminished. It won't actually be any louder, but it will sound louder. So that'll be nice. Is there a sign-up list you can put your name on? No, not right now, right? Like, we'll just do this like easy peasy. And I'm trying to sell one of my watches right now on eBay to fund this project. I've got an old Seiko Flightmaster that I don't really like. It's just way too busy. I'll show you the watch that I'm selling or trying to sell on eBay. A lot of people like it. I mean, obviously, it was a very popular watch. And even there's a company now that is making a watch that's a lot like it, because it was so popular, but it's way too much for me. And, you know, I bought it and I've worn it like 5 times. You know, it's just not, and I've had it for like 4 years and worn it like 5 times, right? It's just not my thing. So it's like, okay, I'm going to sell this watch. But I'll show you the watch I'm selling. Yeah. So this is the watch I'm selling. It's just really, really busy. This is called the Seiko Flightmaster. Model SNA 411, and this has like every feature, right? It's basically a slide rule. You know, it's got, you know, all the markers so you can do math on it. It's got direction compasses. It's got an alarm. It's got, you know, a chronograph. It does everything. It's got a tachometer. It's a goddamn slide ruler on a watch. You know, it's a lot, but it's a lot. There's a lot of markings. There's a lot of markings. It's quite busy. So not really my cup of tea. So I'm trying to sell that right now. I have it listed for 300. I've gotten some offers already for like 350, but I've turned down the offers because I'm just going to let it go to bid. So I'm using this to fund my project. So exciting. Yeah. So if you want to buy that, it's available on eBay. Yeah. You've never been a watch person, just use your phone? Yeah, I've been a watch person forever. I've been wearing a watch basically since I was like in 4th or 5th grade. I've been wearing a watch basically 24/7. I don't take it off to sleep. I don't take it off to shower. I don't take off my watch basically for anything. All right. So, you know, I wear my watch constantly. And so if I don't wear a watch for some reason, it makes me feel really weird because I don't have it on my wrist. But yeah, I love having a watch, and it's still easier to do this than even pull out my phone. All right. So, you know, I mean, obviously you have the time on your phone, but you have to pull it out, but it's still easier to do this. So, plus, you know, as a guy, it's one of the few pieces of jewelry guys get to wear. So that's also nice. So, yeah. But yeah. You stopped wearing a watch when the battery died in your last one? Well, you could just get that replaced, and you can solve that problem by either using an automatic or using a solar. This watch is solar, right? So this watch will last until the capacitor dies, which will take about 15 or 20 years. You know, so yeah. And this is a Citizen, by the way, Eco Drive. And Citizen makes the best integrated solar, at least in my opinion. They're not their only company that uses solar, obviously, but Citizen has the best solar technology because they do the best of hiding their solar, and they do the best of like integrating their solar. So Citizen Solar is the best solar. But you know, if you don't ever want to change a battery, just get a solar powered watch. Seiko makes solar powered. A lot of companies make solar powered. So solar powered will solve your problem. Yeah. Yeah, you can disconnect from your digital life, right? This doesn't do Bluetooth. It doesn't do anything, right? I really like this watch. I like this watch just because it's really easy to read, right? I like this watch for so many reasons. It was a very nice thing that, yeah, but I really like this watch. This is the Citizen Pro Tough, I think it's called. No, that doesn't sound right. Citizen Pro something Tough. What's it called? It's Citizen Pro something Tough. Yeah, but this is a solar powered watch. It just has really easy to read numerals. And this is a solid block of titanium. It's one solid block of titanium, sapphire crystal, anti-magnetic, 200-meter water resistant, so forth and so on. So it's just a very durable, easy to read quartz. And, you know, the watch will last, 15 years before the capacitor goes out. So, for $400, it's solid titanium with titanium bracelet, and it's the tough, and they have their way of making the titanium so it's extra scratch resistant. So it's scratch resistant. The sapphire, of course, is very scratch resistant. The 200-meter water resistant. You can go swimming in the ocean with it. You could go diving with it. It's not rated for it, but you could, because 200-meter water resistant, it'll be fine, unless you're doing saturation diving. But if you're doing saturation diving, we have to have a different discussion. But yeah, you can do anything with it, right? You can swim with it. You can, it's anti-magnetic, and so it just kind of works and just does what it needs to do. So it's very easy to do. So yeah. So if you need to go deeper than 600 feet, you might have to get something else, but this should be fine for any practical purpose. All right, let's discuss what's going on at the Supreme Court, because someone asked me to, and we'll discuss that for a while. Let's see what's happening in Supreme Court land while we're waiting for the court to see if they're going to come back or whatever. Excuse me. By the way, for what it's worth, because some of you guys might not know this when it comes to water resistance on watch, the term refers to static water. So it refers to how deep you go. The reason I make this point is because it doesn't deal with water under pressure. So one of the reasons to have a watch that's 100-meter water resistant is just to be sure, like in the shower, right? Because if you had just a watch that was just normally water resistant, right? Just like a standard water resistant watch, like 30 feet, right? It's like if you have like the cheap water resistant, the thing is like, it's like I won't ever be in more than 30 feet of water. It's like, yeah, but the problem is that deals with only static water. If the water is moving, if you're swimming through it, right, you're moving the water. If there's water falling on it because it's a waterfall, that's moving. If it's water under pressure because it's the head of a shower, that's under pressure. So like you're not supposed to take a wash that's like 30-foot resistant into the shower because the dynamic pressure is more than that. So it's one of the reasons to get 100-meter, because 100-meter you can you don't have to worry about sort of dynamic water. You don't have to worry about the shower and stuff like that. So just in case you cared. All right, let's see what's happening in Supreme Court land. Let's see. The Supreme Court says on Tuesday, Court on Tuesday will consider whether Americans injured in a terror attack abroad or family members of those killed in such attacks can sue the PLO in U.S. courts. So that's the Alien Tort Act. Interesting. Yeah, if 100-meter breaks in the shower, you're doing something wrong. Very much so. Yeah, exactly. Very much so. Very good. Let's see. All right, let's see. What is today? Today is the 1st. Yeah, so today they're having oral argument. We could actually theoretically switch over to oral arguments, although we'd be doing them live. But we could do our oral arguments in Falud versus PLO. That's today. Let's see what's happening recently. Rivers versus Guerrero is the case that someone asked me about. Let's take a look at this. Rivers versus Guerrero. Whether 28 U.S.C. 2244 B2 applies only to habeas filings made after a prisoner has exhausted appellate review of his first petition, to all second-in-time habeas filings after final judgment, or some second-time filings, depending on a prisoner's successive appeal or ability to satisfy a 7-factor test. Whoa, that's a lot. I don't understand the issue from the question. So like I have to read this a little bit to try to figure out what exactly are they talking about. Damn. Subject change, loving the beard. Thank you. The beard has been relatively popular, and I appreciate your saying so. And let's do this. All right, so I'm going to read this petition for cert so I can try to understand what the hell this case is about, because this sounds complicated. All right, let's take a look at this together. So this is the petition for cert. The oral argument was held yesterday, but I want to read the petition for cert to try to figure out what the hell they were talking about. All right. Under a federal habeas statute, a prisoner always gets one chance to bring a federal habeas challenge to conviction. Cool. After that, the stringent gatekeeping requirements of 28 U.S.C. 2244 B2 bar nearly all attempts to file a second or successive habeas. I understand that. Here, petitioner sought to amend his initial habeas application while it was pending on appeal. The Fifth Circuit applied B2 and then rejected the amended filing. Interesting. All right, so this guy is on a first petition habeas, and he wants to amend the petition. The Fifth Circuit says you can't even amend it because you only get one bite at this apple. Interesting. That doesn't sound right off first impression, but okay. The circuits are intractably split on whether 2244B2 applies to such filings. The 5th, 6th, 7th, 8th, 9th, and 11th circuits hold that 2244B2 categorically applies to all second-in-time habeas filings made after the district court enters a final judgment. The Second Circuit disagrees, applying 2244B2 only after a petitioner exhausts appellate review. That sounds more correct to my mind. On first impression, that sounds more correct. But, you know, the 5th, 6th, 7th, 8th, 9th, and 11th circuits disagree with me. So, you know, I'm obviously missing something. Where did I find what I need to make a watch? Where did I find that? I found it basically through YouTube videos. There's a lot of YouTube videos on basically how to make watches at home or how to repair watches. I just watched, 10 different videos. I watched 10 different videos basically on how to make or how to repair watches. And I watched different people go through it, and they go through their steps of doing it. And then, that told me sort of what to look for. And then, I went to AliExpress and found something that seemed to speak to me. So the things I put together was not what anyone else had put together. I didn't follow anyone else's exact plan. But, that's how I learned. I learned by watching, basically 10 videos on the subject. It's a good way to learn something. At least I think so. But thank you for the question. And the 3rd and 10th circuits exempt some second-time filings from 2244B2, depending on whether a prisoner prevails on his initial appeal or satisfies a 7-factor test. Holy shit. The question presented is whether 2244B2 applies only to habeas filings made after a petitioner has exhausted appellate review of his first petition, to all second-in-time habeas filings after final judgment, or to some second-in-time filings dependent on prisoner's successive appeal or ability to satisfy a 7-factor test. Holy shit. Yeah, okay, that's going to melt my brain a lot. I can already tell. But I wouldn't view a request to amend as being second in time. Now, I might deny, am I okay? Sure. Why wouldn't I be okay? I'm in good spirits. Why wouldn't I be okay? I'm happy. Do I not seem okay? I'm very okay. Why do you ask? I'm in good spirits today. Anyways, relating to this, I don't think that I would interpret a request to amend as being second in time. Now, I might deny a request to amend for other reasons, like, the request is too late or, some other procedural bar. I might deny the request to amend for procedural reasons, but I don't think I would deny the request to amend for substantive reasons. I sounded nasally. Yeah, that can be a thing. But that's okay. Yeah, but thank you for asking. No, I'm fine. I just started taking Nasacort again, so that might be slightly affecting my. I'm taking now Allegra and Nasacort to try to deal with allergy issues and stuff like that. But so that might be affecting things slightly. But I'm in good spirits and I'm happy. All is well. So yeah, I think on balance, my initial impression is I would agree with the Second Circuit. Yeah, at least I'm not nasally for the same reason as Ricada. No doubt, right? Okay. So I'm going to skip the factual predicate because it's not really important. And I'm just going to go to the legal issue, because the legal issues are going to tell me what I don't really care about the factual predicate of this particular case. I mean, obviously it's important for the Supreme Court. It's just not important for me right now, because I'm just going to do this on basically the pure law issue. All right. So the court to intractably split over 2244 applies to a habeas filing made after district court has denied an initial petition, but before the appellate court has weighed in. I see. All right. So the problem is, I see. Okay, that makes a bit more sense. So I understand why. I understand the issue now better. Okay. So the problem is when you bring a habeas, you bring it in the federal district court. Okay, cool. So the district court denies your habeas. Okay. And you want to appeal. Okay. Now, if you want to amend, that's basically a second bite at the apple. This is after the district court has already rendered a decision. So I understand the problem now more. It's like, okay, so I went to the district court, I filed my habeas. The district court denied me. I want to appeal, and also I'd like to change the basis of my habeas. So that does sound like a second thing now. That sounds like a second crack at the apple, right? I'm not just appealing based on the district court got my habeas wrong. I'm using whatever the district court said to try to revise my habeas petition. So that does sound like a second bite at the apple. Yeah, no. Okay, so now I no longer think I agree with the Second Circuit. Now I think I agree with the other circuits that basically have said no. I'm not so sure about this 7-factor test thing, but yeah. My skin is looking a bit better. Thank you. I think it's also due to the weight loss. Yes, I think, my skin is looking better. I think that's due to the weight loss, at least in part. And I'm excited about all those things. Progress is happening. Progress is happening, and I'm happy about it. And hopefully, as I continue to lose even more weight, other things will improve. We'll see. All right, let's go on. Let's carry on. That question is critically important to states and prisoners alike as it arises too often to leave open to geographical happenstance. Fair. Decision below is also wrong. Ignores the court's guidance in Bannister, flies in the face of historical practice, and frustrates rather than furthers the ADPA. Finally, this case is an ideal vehicle for the court to offer much needed guidance. The issue is cleanly presented and outcome determinative. Only the Fifth Circuit's mistaken reading stands between rivers and a meaningful path. Okay, cool. You're looking great. Thank you. I appreciate that. 9 circuits have split 4 ways over the question. Lol. In the Second Circuit, 2244 does not apply until the petitioner exhausts appellate review of his first petition. The 5th, 6th, 7th, 8th, 9th, and 11th circuits disagree, holding it applies as soon as or shortly after the district court enters final judgment. Even they can't agree on the precise trigger. Lol. Meanwhile, the 10th Circuit applies 2244 even earlier, except when petitioner satisfies the 7-factor test. And the Third Circuit toggles on and off depending on whether the petitioner wins or loses on appeal. Yikes. Respondent acknowledged the split below and only this court can resolve it. Okay. In the Second Circuit, 2244 does not apply until appellate review of the first petition has been exhausted. In Waub versus United States, Second Circuit held 2244 does not apply while appellate proceedings follow the district court's dismissal of the initial proceeding remain. Usami Wasab filed a pro se petition. District court denied and declined to issue a certificate of appellability. Waub then saw a certificate of appellability from the Second Circuit, which was denied. While the motion was still pending, however, they asked the Second Circuit for permission to file a second or substantive petition. The court held that the subsequent petition was not a second petition within the meaning of the AEDPA. Citing then Judge Sotomayor's rationale in Ching versus United States, it explained a petition cannot be second or successive unless it's filed after conclusion of a proceeding that counts as the first. And the first proceeding isn't over until the opportunity to seek review in the Supreme Court has expired. That's perfectly reasonable too. That's a perfectly reasonable position. We don't normally talk about finality until, yeah, that sounds right. Yeah, I seem less angry. Yeah, I think on the whole, I'm less angry. I mean, sometimes I'll still lose my temper, but yeah, I think that's true. I think that's also just generally true of me getting better very gradually with respect to depression. Depression is still an issue, but I think I'm healing, albeit sometimes slowly, even glacially. But yes, I think I'm happier more often. So hopefully that will even continue as I lose in weight. It can't hurt. It can't hurt, that's for sure. But I appreciate the compliment. That's nice of you. All right. And the first proceeding isn't over until the opportunity to seek review is expired. Because Wahhab's first proceeding was still pending when he filed a subsequent petition, it does not apply. Of course, this does not mean anything goes. Traditional doctrines such as abuse of writ continue to apply. So even if filing is not second, prisoners do not get a free pass to file numerous petitions before initial file petition is finally adjudicated. Fair enough. So it's not necessarily a substantive bar, but there might be a procedural bar. So I appreciate that. That makes sense. Neither can prisoners present adjudication from becoming final by extending the first habeas proceedings through an infinite number of first petitions. Fair. 2244 kicks in when the time to file a petition for certiorari expires, whether or not a file-up is still pending. Okay, I mean, that is an approach that makes sense. I sort of understand that. All right. In the 5th, 6th, 7th, 8th, 9th, and 11th circuits, 2244B2 applies when the district court enters final judgment. 6 courts have expressly rejected the Second Circuit's approach, holding that 2244 is triggered at or around the time the district court enters final judgment. Yet even these courts cannot agree on exactly when. In the 5th, 7th, 8th, 9th, and 11th circuits, it applies as soon as the district court enters final judgment. That sounds rational. The 5th Circuit below recognized the split and declined to embrace the Second Circuit rule, holding that it applies after entry of the final judgment. District Court denied Danny Rivers' pro se habeas and entered final judgment. 5th Circuit then granted a certificate of appealability as to Rivers' ineffective assistance of counsel. While the appeal was pending, Rivers sought further review. Applying 2244, the District Court deemed Rivers filing a second petition. According to the 5th Circuit, 2244 covers filings introduced after final judgment that raise habeas claims. The court derived that rule from this court's decision in Gonzalez. The prisoner in Gonzalez did not file for rehearing or review in his first habeas proceeding and then sought Rule 60 relief a year later. The court held that 2244 did not apply because prisoner's 60B motion did not raise a habeas claim. The 5th Circuit read Gonzalez to stand for the underlying principle that 2244 applies after final judgment, lest prisoners use post-trial motions to evade. Wow, this is some really geeky law shit right now. This is pretty geeky stuff. It's very consequential geeky stuff though. So it's geeky consequential law, and I'm here for it. But I feel like I have to notch my intelligence up because this is a bit complicated. So I feel like I have to push myself on this one, which is a fun feeling. Oh, the proceedings are streaming again? Are they? No, they're really not. At least according to this, they're not. But hold on. Maybe this feed is not giving me the correct information. Hold on. Let's see. Hold on, please. Please talk amongst yourselves while I double check. All right. Can I wake up? In the morning I wake up, say a little prayer for you. Together. It looks like you might be right. It looks like proceedings are starting again. Exciting. And I will boost the court audio because I promised to do so. So I'll boost it up and then restrict it back down as necessary. But awesome. Thank you for joining me for that brief Supreme Court break. No, this is not. This is the prior trial. This is previous footage from the previous trial. The court lies to me. The Channel 5 Boston deceives me. They're a bunch of liars. Yeah, no, it's not streaming. No. Okay, back to the Supreme Court. Back to the Supreme Court. I don't blame you. You saw a court hearing happening. That wasn't your fault. No problem. But yeah, that was back to the Supreme Court. All right. Anyways, as I try to figure out this very, very technical habeas issue. All right. Ninth Circuit also applies 2244 as soon as the district court has adjudicated a habeas petition on the merits. While denial of the habeas petition was still pending appeal, they sought additional relief in district court. District court deemed a subsequent filing an unauthorized second or successive petition, and Ninth Circuit affirmed. Citing circuit precedent, it held 2244 applied because they sought to add a new claim after the district court denied the petition. Has the Sixth Circuit rendered an opinion on this issue? Is the Sixth Circuit one of the court circuits that rendered an opinion, because they're always wrong on habeas? So if the Sixth Circuit rendered an opinion, then I know it's not that. Judge Fletcher wrote secondly to urge the Supreme Court to recognize the Second Circuit split and adopt the Second Circuit rule. It's viewed the Ninth Circuit made a mistake, both as a matter of ordinary language and as a practical matter. As text, he realized reason 2244 only applies once an appeal has been finally adjudicated. Yeah. As a consequence, he explained, the Second Circuit rule will not result in a flood of late or procedurally abusive claims. Yeah, I mean, I appreciate that. We can solve this problem. To the extent this is a problem not barred by statute, we can solve this problem procedurally. So if this is not statutorily barred, we can prevent people gaming the system by procedure. So that also makes sense. He closed by encouraging the court to resolve the conflict in the circuit and expressing optimism they agreed with the Second Circuit rather than the Ninth, but they didn't. The Seventh Circuit also holds final judgment triggers 2244. While the Seventh Circuit was reviewing habeas, Dave Phillips asked the district court to consider newly discovered evidence. District court denied, but Seventh Circuit approached things differently, held the new filing was not properly before the district court in the first place because it was second or subsequent petition. That was so because final judgment marks a terminal point, and treating motions filed during appeal as part of the original application would undermine time and number limits. Fair. So, yeah, okay, I understand that. So this might actually be like a statute of limitations problem, basically, right? So you can't amend a petition in a lawsuit in a substantive way after the statute of limitations has passed. You can't add new claims because the statute of limitations has passed, right? So you can't file a claim at the last minute and then like do a string filing, basically. You can't do that, right? It's like, okay, so imagine the statute of limitations is 3 years. I file it, 1 day less than 3 years. And then, okay, let's say 6 months later, I want to amend in a substantive way and be like, I'm still within the statute of limitations because I'm amending my pleading. No, right? It's like, no, you can't amend it substantively. So if we're talking about time limits within the AEDPA, then that might be a bar for that reason, because it's basically a statute of limitations on when you can bring the claim. So maybe that's the right answer. The Eighth Circuit followed a similar approach. After a district court who asked me incidentally to cover this case in chat, because this is super duper duper geeky. Like, I just want to know who asked me to do this, because this is uber geek. So whoever asked me to do this is like, man, you are uber geek law nerd, and I respect you, man. Man, yeah. The Eighth Circuit followed a similar approach. After district court denied Frank Williams habeas, it failed to enter a separate final judgment. In the brief period before the order became final, Williams moved to amend. District court denied both motions as second or subsequent petitions. The Eighth Circuit affirmed, reasoning that district court had intended to dispose of the filing on the merits, so later were post-judgment. The 11th Circuit also applies 2244 after final judgment. The Sixth Circuit, so the Sixth Circuit did render an opinion, and all I know for sure is that the Sixth Circuit is wrong, because they're always wrong on habeas. That's what I've learned from the Supreme Court. The Sixth Circuit is always wrong on habeas. So if the Sixth Circuit rendered an opinion, it must be wrong. Lol. The Sixth Circuit follows a slightly different rule, tying 2244 to the opportunity to appeal, not entry of the final judgment. Samuel Moreland's initial habeas petition was still pending on appeal when Moreland sought further habeas review. Yeah. Let me make this text a little bit bigger, because, yeah, hold on. I'm going to zoom in a little bit here. There we go. That's better. There we go. That's better. Salem Moreland's initial petition was still pending on appeal when Moreland sought further habeas. But instead of pegging 2244 to the entry of final judgment like the 5th, 6th, 8th, 9th, 11th Circuit, 6th Circuit focused on the window for appeal. In his view, the motion that seeks to raise habeas claims in a second petition, when filed after petitioner has appealed denial or after the time for petitioner to do so has expired. In other words, courts in 6th Circuit asked where a district court lost jurisdiction. That means a petitioner who was out of luck in other circuits could get relief in the 6th Circuit while the window to appeal is still open. Yeah. I mean, it's quite obvious why the Supreme Court took this case, right? It's like, oh yeah, no. Habeas petitions come up a lot. They come up a lot. And we've got like, yeah, we got a four-way split. So no surprise the Supreme Court took this case, man. Damn. This is Supreme Court fuel, man. In the 10th Circuit, 2244 applies after first time unless they satisfy a 7-factor test. Holy shit. 2244, whenever a second time petition raises second and distinct claim, even if the first time petition is still pending in the district court. So basically, like, yeah, you can't amend it substantively. That rule puts the 10th Circuit odds with not only 2nd Circuit, but all the other circuits. But petitioners in 10th Circuit can avoid this otherwise strict rule when justice demands. Woof. While appeal of the first habeas was pending, Yancey Douglas asked the 10th Circuit for petition to file a second application, asserting prosecutors had concealed information. 10th Circuit acknowledged that under OCHA, it would not ordinarily permit it, but this was no ordinary case. Holy shit. Rather, based on 7 factors, including Douglas's initial habeas petition remained pending, newly claimed, related, and close to pending claims. I'm pretty confident whatever the Supreme Court is going to do, they're not going to adopt the 7-factor test. That does not sound like something the Supreme Court's going to do. Yeah, no. So I'm pretty confident the 10th Circuit is wrong. I'm not sure in what way they're wrong. But the Supreme Court's not going to go for this 7-factor bullshit. No, that's not a thing that's going to happen. In the 3rd Circuit, 2244 toggles on and off depending on who wins the initial appeal. How about 5? Can we go with 5? Lol. Finally, the 3rd Circuit files its own unique rule. It agrees the 2nd Circuit, 2244, does not automatically apply to second petition filed before exhaustion with respect to denial of habeas. But prisoners in Delaware, New Jersey, and Pennsylvania face a twist that those in Connecticut, New York, and Vermont do not. When a prisoner in the 3rd Circuit seeks habeas relief while its initial petition is pending, the application of 2244 depends on the outcome of the appeal. Here's the 3rd Circuit's logic. While the first petition is up on appeal, petitioners not had one full opportunity to seek collateral review. Fair. So a subsequent petition filed during that period should be construed as a motion to amend. I understand that. That motion belongs in district court in the first instance. That makes sense. If the district court lacks jurisdiction while the appeal is pending, so the motion to amend must stay on ice. Fair. Now for the twist. If the 3rd Circuit, if the 3rd Circuit vacates or reverses and remands, district court would again be vested with jurisdiction to consider that motion. When that happens, 2244 does not apply. Well, that sort of makes sense because if they reverse, then we're normally back to square one. I mean, for the most part, but then again, still statute of limitations issues and so forth and so on. So yeah, even then you couldn't amend if it was a statute of limitations problem, right? It's like, yes, I won my appeal, but I can't necessarily amend it in a substantive way. Okay. Yeah. On the other hand, if the prisoner exhausts his appellate review to no avail, they've expended one full opportunity to seek collateral review. In the case 2244 does apply in presto, the motion to amend becomes a second habeas petition. Well, maybe, maybe not. That's sort of a legal conclusion, but not necessarily. Only this court can resolve the conflict. 3 circuits have already denied a rehearing on Bonk, and one of them has done so twice. Yeah. The others show no signs of rethinking, nor is there any need for more percolation. 9 circuits have already weighed in cover 88% of the country. All the positions are staked out, and the court has the benefit of numerous opinions. Yeah, there's no real reason for this to further percolate, right? There's no real reason to try to give, more time for the courts below to figure this out. So I understand all those things. Yeah, I still don't know what I think about the issue, though. That's fun. I still don't know what I think. The question presented is too important to punt. Since 1996, AEDPA cases become a fixture of the court's docket. In fact, the court has repeatedly granted cert to resolve conflicts. It's also critical on both sides, blah, blah, blah. Yeah, the need for review is all more pressing, blah, 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 blah. Decision below is wrong. The Fifth Circuit thought 2244 required district court to dismiss for lack of jurisdiction because the filing was introduced after final judgment and raised habeas claims. That's wrong. Bannister showed how courts should determine what qualifies as second or successive. Okay. And its logic favors Rivers. But the Fifth Circuit didn't even cite Bannister, let alone engage in the proper analysis. And its rule doesn't square with the court's holdings either. Accusing the Fifth Circuit of just completely ignoring a Supreme Court decision is one hell of a claim. I mean, you better back that up, man, that they're just completely ignoring the Supreme Court. It's like, they probably didn't think it applied, but it's like you're just accusing them of blatantly ignoring the precedent. Damn. 2244 does not apply until appellate review is exhausted. The phrase second or subsequent application is a term of art that's not self-defining. According to Bannister, apparently. Okay. To determine whether 2244 applies, this court has looked to guidance in 2 main places. First, history. Whether a type of latter in time filing would have constituted an abuse of the writ, as that concept is explained. Second, AEDPA's own purposes, conserving judicial resources, reducing piecemeal litigation, and achieving finality within a reasonable time. Here, both factors align. Early courts applied abuse of writ rules in light of appellate review, not final judgment. And applying 2244 to filings like Rivers would frustrate, not further, the aims. The abuse of writ doctrine was a 19th century innovation. Yeah, I mean, again, that's more of a procedural thing. So, like, if we're just off into procedural analysis land, then but are we doing substantive analysis land or are we doing procedural analysis land? Right? Is this statutorily barred or is it procedurally barred? Those are not the same thing. So the abuse of writ doctrine was a 19th century invention, which is hard to believe that it took that long. By the common law of England, as it stood the adoption of the Constitution, null of habeas was no bar to issuing a second or third more writs by another court or magistrate having jurisdiction. So in the common law tradition, you might have multiple habeases. Fair enough. Instead, courts and judges were accustomed to exercising independent judgment on each successive application regardless of another. Only later, once the right to appellate review was given, did American courts pare back the practice. So apparently they didn't have the right to appellate review necessarily in the common law, which is correct. There is no fundamental right to appeal, which I know is amazing, but it's true. Like, there is no fundamental right to appeal. That's true. The Supreme Court has never held there's a fundamental right to appeal. So yeah, that's the common law. I mean, it is what it is. It is what it is. So once we kind of decided that maybe there should be a fundamental right to appeal, then we had to reconsider some of the doctrines that did that as a result. Is this April Fool's joke? No. When they did, they tied back abuse of writ rules to the completion of appellate review. Ex parte Cuddy, one of the earliest abuse of writ cases, is a good example. A district court denied Thomas Cuddy's habeas petition. The court affirmed. Cuddy then sought habeas relief. Justice Field ordered the writ dismissed, reasoning a second application should not be heard absent leave to make a new application. Along the way, Justice Field emphasized 2 things. First, the action on the second application should turn on the character of the court or officer to whom the first application was made and the fullness of consideration. Blah, 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 blah. It's court's abuse of writ. I'm moving past that abuse of writ stuff. All this boils down to this. When early courts applied abuse of writ rules, they asked where the appellate decision maker had spoken, not where a district court maker had applied final judgment. Any reaction to Carl versus Billy Mitchell? Oh, how did that case resolve? How did the Billy Mitch case resolve? Is it over finally? Did Billy Mitch get his ass handed to him? I imagine that he did. But I'd be interested to hear more on that issue. Billy won? Really? Billy won on a defamation? Seriously? Billy won his defamation claim? Wow. Really? Wow. How? How do you win that? Wow, he won on his defamation claim. How? That's interesting. Yeah, that's not the result I was expecting to hear. That was not the result I was expecting to hear at all. Maybe there was some aspect to the claim that I wasn't really properly understanding. Maybe I just didn't properly understand the claim because I never really got super deep into it. So maybe my understanding is really superficial, and maybe there's some technical aspect to it that I'm not understanding. But yeah, that's the strikes. Yeah, but then again, like I thought Johnny Depp didn't really have a claim on surface level analysis either. So maybe like Johnny Depp, I was just wrong on surface level. Maybe there's more going on there than I understood. But that's interesting that he won. Because of the self-deletion accusations drawn from other YouTubers? Okay. Yeah, Donna, I try to analyze as every issue unto itself, right? It's like, this is what I try to do. And some people get frustrated by that, but I think it's the only reasonable way to do things, right? If we think the judge is biased, the correct answer to solve that problem is try to be unbiased. But just because the judge is biased doesn't mean the judge is wrong. The judge could be biased and right. So yeah, I try to assess things more nuanced. It was more than just about cheating. So it was more than just about cheating. That makes a lot more sense. Okay, that makes a lot more sense. So there were claims beyond just the cheating allegations. That makes more sense. Against the backdrop, a rule that treats final judgment as relevant. Also, by the way, you said something about Australia. So are you referring, because I remember that there's a Billy Mitchell, apologize. There was a Billy Mitchell defamation lawsuit in the United States. I was unaware that there was one in a different country. So he won in a different country? He won like in Australia or something? Then that would obviously change things radically. If he won like in the UK or he won in Australia or something, he won in Australia. Okay, now that's a lot different. Yeah, so obviously Australians' conception of defamation is not necessarily the same as the United States. Okay, that makes a ton more sense. Okay, that makes way more sense. Okay, yeah, then in that case, basically I have no opinion. In that case, I have no opinion. I don't know enough about Australian defamation law to render an opinion without actually getting into it, right? If I actually got into it, I could probably understand it because, of course, Australia, like the United States, derives its law from the common law tradition. So there's enough in common that if I got into it, I could figure it out. But they're going to deviate in fairly material ways. So I'd actually have to get into it and actually try to figure it out. But that makes way more sense. Okay, he won in Australia. Okay, never mind. Never mind. I retract my earlier confusion. Bannister's other source of guidance, AEDPA's own purposes, points the same ways. Treating filings like Rivers as second or subsequent with baleful implications for habeas practice. So far as lower courts are concerned, the question is not whether prisoners like Rivers will seek further relief while their initial petitions are on appeal. The question says which court will review those filings. Everyone agrees that the three-judge panel of the Court of Appeals is the first port of call for petitioners filed after prisoner exhausts appellate review. But Congress had little reason to channel filings like Rivers down that path, and for good reason, to treat them as part and parcel of the initial habeas application. If Section 2244 is a rocky path for prisoners, that goes doubles for court. Yeah, and incidentally, by the way, then I probably won't be doing anything more on the issue relating to Billy Mitchell, because I'm not really necessarily competent, without really digging into it. Unless, of course, there's like a full written decision by the court. So if it isn't just a jury found it, if there's a full finding that lays everything out in legal detail, if there's an actual legal opinion, then I could track that, because I would understand it. But in the absence, is the court coming back? I don't know. I don't know whether the court's coming back or not. We're just here for I don't know. There's a full written decision. Okay, cool. So if there's a full written decision, then I might cover it, because that sounds interesting. And I would be able to track it because the court would explain its reasoning and I'd be able to follow along. I might not necessarily be able to critique it the same way I would a U.S. case, because I wouldn't be in a position really to be like, oh, no, this court is wrong, right? Because I know U.S. law well enough that I can be like, no, the court's wrong. Probably wouldn't be able to do that in an Australian case, but unless it just seems like absolutely on its face bizarro world. But yeah, I could try to track an opinion. So I'll tell you what, how about this? If you find a full written decision relating to this, provide it to me on my Discord. I'll give it a look-see and see if I can provide something that makes sense. And I'll strongly consider doing it. So if you find a full written decision, post it on my Discord, and we'll go from there. Let's see. Then they have to examine evidence as a whole. If proven, then turns means considering state's theory of the case. Blah, blah, blah. Now consider alternative. With Rivers sought further review, he's before the same magistrate judge who denied the petition. How those judges reach the merits? They better than anyone would know whether or not the new evidence was worth the candle. If not, game over. So the court could have issued inductive rulings. Either way, a judge familiar with habeas would likely make quick work of filing like this. Ooh, I don't know about that. There's good reason to think Congress concerned about judicial resources would view such filings as part and parcel of the first habeas. Yeah, I don't know about that one. Okay. When a court of appeals receives a second petition, 3 appellate judges have to decide from square zero, and often without adversarial briefing, where new evidence could have been discovered through exercise of due diligence. Then they have to examine evidence as a whole, determine whether the facts underlying claim have proven to be sufficient to examine. That in turn means considering the state's theories of the case, evidence including how they do that, and even alternative theories. One recent authorization case was pending before Fifth Circuit for almost 3 years, and the opinion featured a 2-column, 16-row chart that spans 3 pages. Yikes. And that's just the first step. Even where the appellate court authorizes the petition, district court must conduct its own thorough review to ensure the requirements have been satisfied. Because any claim presented in a prior application must be dismissed, both courts must be careful to compare a second or subsequent petition. Now consider the alternative. When Rivers sought further review, he went before the same magistrate judge and district court who denied the initial petition. How those judges reached the merits, they better than anyone would have known where the new evidence was worth the candle. If not, game over. If so, well, not really, because you'd still be able to appeal. If so, the court could have issued an indicative ruling under Federal Rule Procedure 62. Either way, a judge familiar with the habeas petition would likely make quick work. There's good reason to think Congress concerned about judicial resources would have viewed the following as part and parcel. The latter would, reducing piecemeal. The latter path would serve AEDPA's second aim, and this is exhibited in Case A. Rivers asked the Fifth Circuit to remand so they could seek habeas relief on all of his claims that are revisiting. When that failed, he asked the district court to consider interlocutory review to prevent unnecessary litigation. Instead, the court transferred the matter to the Fifth Circuit, which opened a brand new proceeding. Finality cuts the same way. Suppose state investigators report that Rivers discovered his client file isn't the bombshell that Rivers reckons. In that case, the way to lend finality to Rivers' conviction within a reasonable time would have been for the district court to say so in September 2021. Had it done that, the case would have been over. Yeah, right. Instead, the lower court sent Rivers and Texas down a path that could prolong the case for years to come. Had Congress wanted all post-judgment habeas petitions to count as second petition, it could have easily written that. But it's hard to squeeze that from the text and history. Yeah. The Fifth Circuit addressed none of this. It did not ask whether Rivers' filing would have constituted an abuse of writ. It did not explain how the approach would conserve judicial resources. And while it offered vague generalities about evading ADPA limitations, it said not a word about finality. In fact, the court didn't even cite Bannister, even though both parties relied on the case in their briefing. Nor did this court approach square with the rule. Gregory Bannister's Rule 59E motion came after final judgment and raised habeas claims. But this court still held that it was part and parcel of the first habeas. Likewise, the petitioner Slack filed post-judgment habeas petition, and the court allowed that to proceed too. The same was true in Stewart, where the court's prisoner's final judgment habeas was not second or subsequent. Wow. Wow, what a technical nightmare. What an absolute technical nightmare. This is... I feel like I barely understand the issue. Barely understand the issue. That doesn't happen very often with the Supreme Court, but it does happen occasionally. But I feel like I'm out of my depth on this one. I mean, to be fair to myself, it's a very technical aspect of habeas law. And, you know, while I understand habeas law pretty generally, this is very technical and very niche and a little out of my depth. Yeah. You can't hear questions when I talk. Yeah, well, you know, my audio is supposed to be slightly louder than the court, obviously. That's by design. So, you know, obviously when I talk, it's meant to, and there wasn't anything you were missing, I assure you. I would try to avoid talking if it mattered. It didn't matter, I promise. But thank you anyway for your participation. All right, I think what I want to do now, because I don't think the court is coming back, I think maybe I'm going to do an oral argument react to this case. Because this sounds like nightmare fuel. And I feel like melting my brain today. So, this is so... Ugh. Rivers versus Guerrero. Okay, there's no synced transcript yet. So I won't do an oral argument react today, but maybe in the future. I will read the facts of the case. The facts of the case are thus. In 2012, Danny Rivers was convicted in Texas State Court of multiple charges related to abuse of a child and possession of the child pizza. He filed his first federal habeas petition in August 2017, challenging these convictions, which was denied by the district court in September 2018. While his appeal of that denial was pending, Rivers filed a second habeas in February 2021, raising new claims after obtaining his attorney-client file through a state bar grievance in October 2019. The district court deemed the second petition successive under the AEDPA and transferred it to the Court of Appeals for Fifth Circuit for authorization, but Rivers failed to file the required motion for authorization. After the Fifth Circuit ultimately affirmed denial of the first petition, Rivers appealed the transfer order of a second petition, arguing it should have been treated as a motion to amend his first petition rather than a subsequent petition, since his first petition was still pending. Holy shit. Yeah, did you miss it? Yes, you did. They just read in the general rules. That's all that we were expecting to see. We weren't expecting to see anything more. So we might do that oral argument on a different day because that sounds like melting my brain. What a case. NRC versus Texas. What is the Nuclear Regulatory Commission up to? Where the Hobbs Act, which authorizes a party agreed by final order petition for review in the Court of Appeals, allows non-parties to obtain review of claims, asserting that an agency order exceeds statutory authority. No? How do you have standing? Whether the Atomic Energy Act of 1954 and Nuclear Waste Policy of 1982 permit the NRC to license private entities to temporarily store nuclear fuel away from nuclear reactor sites when the spent fuel was generated. What the hell? That doesn't sound fun. All right, so what else should we do today with our time? I'm not necessarily. I'm in a good mood, and I kind of want to keep streaming if there's something more for me to talk about. So, what else can we talk about? I suppose we could just pull a random Court of Appeals case and talk about that for a while. Let's see. How am I doing in terms of viewership? 334. You guys are still here? Excellent. A law of the question, can defense call as many witnesses as they want? Yeah, broadly speaking, yes. The defense can call as many witnesses as they want as long as they're not repetitive and unduly cumulative, yes. What do I think of the new JFK documents? I haven't read them. I was just waiting for other people to cover them and see what there is. I don't understand there to really be anything brand new in there, but, whatever. I look fantastic. Thank you. That's nice of you to say. Let's see if there's some sort of random Court of Appeals case that looks interesting for me to cover. Looks like a case of mobile superintendents in Virginia charged with several special education violations in RICO. Wow. That's a lot. Did I read the Commonwealth is trying to get rid of the dog trainer? No. Any chance I could briefly touch on tariffs? Yeah, I'm not sure I can necessarily offer much intelligent in the way. Thinking about panic buying some Euro trash gun parts, etc. before tomorrow. Yeah, I'm not sure how much intelligent I can really offer on the subject. Tariffs are a import tax, is what they are. They are paid by the importer. They are meant to increase the cost of the goods. That can accomplish many different objectives. One of which, of course, is to potentially drive business inside the United States where there are no tariffs. Because, one of the things that it does is by increasing the goods elsewhere, makes it then potentially more economically viable to make those parts inside the United States or whatever. And so that potentially increases jobs. It potentially increases manufacturing base. It also potentially can be used for national security reasons because, we need the chips, for example, made inside the United States. So we don't have that threat to our national security if Taiwan gets taken over. It can be used as a tool to pressure a different country into doing something. So you're using economic pressure to get the country to do your will. It serves multiple different potential purposes. As to whether or not it's wise or not. And of course, tariffs exist. And there's a big book of tariffs. And the president wanting to increase tariffs, okay. So yeah, that's basically what I have intelligently to say about that. Yeah, that's basically, and how long those tariffs will last, who can say? So it will make the cost of goods more expensive in the short term. What about hearings to impeach federal judges? They'll never do it, and it's a stupid thing to really try. They'll never convict. I wouldn't worry about it as a judge. I'd be like, stop wasting my time. Even if they successfully pass the impeachment, I wouldn't care. The Senate will never convict. It's bullshit. I understand why the exporter has to pay it. That's just not the way it goes. I mean, obviously the importer pays it, and the importer can try to pass that cost along, but the importer is the one who pays it. That's the way it goes. Yeah, and you can't force someone else in a different country to pay. Yeah, how would that work? It's like, how do you force the exporter to pay it? What jurisdiction do you have? And even if you had jurisdiction, how do you actually do that? How would you actually affect the judgment? Right. So even if you had jurisdiction over this exporter in China and you're like, okay, pay me money. And they're like, no, what are you going to do? How are you going to affect this judgment? They're in China. Right. So yeah, that doesn't really work. Any idea if I make the purchase now before tariffs, if I have to pay? Presumably the answer to that question is no, right? If you pay now based on the rates they're charging now, then presumably you wouldn't have to pay because that's not what you agreed to. And if they demanded that you pay more money, you could be like, no, that's not what I agreed to, because it's a material change of the term. If they're going to increase the cost, that's a material change to you. So presumably you'd be able to bail out of it. Are they still going after murder too? For the moment, they are. For the moment, they're going after murder too. Do we know what they're doing off camera? Yeah, they're doing individual voir dire. The jurors is what they're doing. They're bringing the jurors apparently up one by one to the bench and asking them questions in a somewhat methodical way. Yeah. I don't think there's going to be any more streaming until the trial starts. And if there is, it's just going to be more of exactly what we already heard. So I don't know that I'm going to stream any more of the Karen Read trial until the trial actually starts, at which point, of course, I will stream the whole thing, soup to nuts. Do I think this trial will be shorter or longer? I would imagine it would be roughly the same length. There's no reason to believe otherwise. But if it were anything, it would be slightly longer, I'd imagine. Hey, 50 gift memberships. That's really generous. Thank you very much. She's like Texas. That's very, very kind of you. 50 gift memberships. Wow. Thank you. Thank you very, very much. Aw, that's nice. Thank you. You're the best. Let's see. All right. So let's see. I put in quote marks. Yeah. Let's see what looks interesting in federal court of appeals land. And let's see. We did the wife husband thing. Excuse me. Detroit man spends 15 years in jail for a murder he didn't commit, based primarily on inconsistent and retracted testimony of an eyewitness who identified him from a standalone photo, not a photo array, yikes, that did not match the witness's prior description of the shooter. After exoneration, he sued the detectives on the case. The Sixth Circuit, no qualified immunity for due process claims for withholding evidence and using an overly suggestive identification. Concurrence, that's what our precedents require, but I'm not sure suggestive identifications are themselves constitutional violations, and we should give more qualified immunity in suppressive evidence cases. Chicago man spends 15 years in jail for a murder he didn't commit, in part because police showed its suggestive photos. Seventh Circuit, which isn't a violation of due process. So the Sixth Circuit disagrees with the Seventh Circuit on a very similar fact pattern. That's funny. All right, this sounds fun. Whittier, California. Police take a woman to the ground without warning during a 2020 police appreciation parade. Lol. A counter-protester, she'd been yelling expletives to express her distaste for police brutality. Once on the ground, she tries to bite an officer, resulting in more rough handling that necessitates surgery for nerve damage. The Ninth Circuit. And since the video doesn't show any law breaking prior to arrest, her claims must proceed to trial. That sounds fun. She's bitey. She's bitey. I like it. Let's skim this one. This is cool. We turn our attention to the Court of Appeals for Ninth Circuit in the case of Joel Savage versus Paul Segura and Jeff Piper. This is fun. The Whittier Police Department officers Paul Segura, Mark Goodman, John Draper, Michael Prisbel, Jason Zirkle, and Jeffrey Robert appealed the district court's denial of motion for summary judgment based on qualified immunity. We have jurisdiction. To determine whether qualified immunity applies in a given case, we must determine whether the police officer has violated plaintiff's constitutional rights and whether a particular right the officer has violated was clearly established. We've read this many, many times. For a right to be clearly established, it must be sufficiently clear that every reasonable officer would understood ways doing is violating their rights. We affirm the district court denial of qualified immunity to officers Segura, Goodman, Draper, Prizzle, Zerker on Savage's Fourth Amendment unlawful arrest. Savage has raised a genuine issue of material fact as to whether WPD officers had probable cause to arrest her for violating Section 21950 or 21954 of California's Vehicle Code. Considering the disputed facts in the light most favorable to Savage, WPD had blocked off Washington Avenue to all non-caravan traffic. Both pro-police and anti-police demonstrators walked through the street, and caravan cars traveled at extremely slow speed while frequently stopping. Savage's version of the facts, moreover, is not blatantly contradicted by video evidence. On these facts, there's no indication that Savage walking, and how does that violate the Vehicle Code is beyond me, right? How does walking violate the Vehicle Code? On these facts, there's no indication that Savage walking among the caravan cars posed an immediate hazard or she unexpectedly asserted her right-of-way such as virtually impossible to avoid an accident. Yeah, it sounds like one hell of a pretext to me. Nor is there any indication that Savage posed an immediate hazard to others based on these Vehicle Code provisions. And Savage's right to be free of unlawful arrest was clearly established at the time of the incident as she was unarmed, posed no threat, and was not engaged in criminal activity. The WPD officers also argue that officers Prisbel, Zirkle, and Robert cannot be held liable for any constitutional violation because they did not physically arrest Savage. But a police officer need not be the sole party responsible for a constitutional violation before liability may attach. An officer's liability under 1983 is predicated on integral participation. Yep, like, did you assist? Are you an accessory? Basically, yeah. As such, the district court did not err in finding a reasonable jury could conclude officers Prisbel and Zirkle were integral parts. We find, however, Officer Robert was not an integral participant merely because he was present on the roof. Yeah, that doesn't work, right? He wasn't assisting in the arrest. He was on a roof, man. What is he doing, right? So he's not involved. Under the circumstances present here, his actions were more akin to a bystander. Fair, I agree. We affirm the district court's denial of qualified immunity for Segura, Goodman, Draper on Fourth Amendment excessive force. First, Savage has raised a general issue of fact as well as the officers use excessive force. Viewing disputed facts in the light most favorable to Savage, officers Goodman and Draper failed to give any warning, arrested by surprise, grabbed her arms, dragged her to the ground, pressed her face in the asphalt, placed a knee on her back hard enough to affect her breathing, and handcuffed her so tightly that her arm bled. Yeah, they did it because of speech. They did it because of speech. They did it because she was saying the police blow chunks during a pro-police parade. She was walking in the pro-police parade and she was saying, police suck balls. And then they just threw her to the ground, right? Without any warning. Could they have ordered her to leave the parade? Maybe, right? Because maybe that's not the place for her to be. Time, place, manner restriction, right? This is a parade. It was set up in advance. It was for this purpose. These people have a message. You're contrary to the message, right? So could they have asked her to leave the parade and, say her obscenity somewhere else? Yeah, maybe they could have done that. Could they, without warning or order to move along, just throw her to the ground? Not so much, no. That's a problem. That's a problem for a bingo, right? Moreover, the severity of Savage's alleged crime is minimal, and they've really tried to stretch. It's like, oh, no, the problem is that she was like interfering with the cars, like everyone else in the parade. You know, again, unless you can show that she was like, you know, deliberately standing in front of the cars or like beating on the cars or something. No, right? It's like you're really trying to stretch to make this work. We're not dumb. Is de minimis exception being removed tomorrow? That's my understanding, that the de minimis exception is being removed, which exposes all kinds of problems. Yeah. So yeah, that could make things challenging for Uncivil's wash hobby. I might have to increase my prices. Second, it was clearly established at the time of the arrest that such significant force on Savage, who was suspected of minor crime and posed no threat, was unconstitutional. And even considering Savage's attempted bite while she was on the ground, an officer's non-trivial force is not justified in the face of passive or even minimal resistance. A person has a right to offer reasonable resistance to his arrest. That's a product of an officer's personal frolic. Yeah, I have no problem with any of that. That sounds fine to me. So you go, girl. You go get him for your abridgment of your freedom of speech. You go get him. That's a fun case. Let's see what else is happening. Yeah, AliExpress is going to get expensive because they have to pay all the proxy at ports plus taxes. Yeah, well, could do. Well, could do. Yeah. Okay, I don't really like any of those other cases. What else we got? Yeah. So the DC Circuit said that AI generated images do not get copyright either. So, yeah. This is Stephen Thaler. Of course it is. Yeah, so he's still trying to get AI generated images copyrighted, and no. He's going to go to this court. He's going to go to the Supreme Court, and they're also going to say no. Mm-hmm. Ooh, dear. Generally, parties charged with burglary, narcotic offenses, sexual assault, and running a prostitution ring do not fare well in federal court. So how badly did the Syracuse, New York officers mess up a 12.5-hour search and seizure of the defendant's resident for the Second Circuit to vacate? Holy shit, right? It's like, okay, so we're going to, how badly did you screw this up? Holy shit. We turn our attention briefly to the case of Troy Alexander versus City of Syracuse. Okay. On the evening of October 24th of 2016, members of Syracuse Police Department arrived at the home of Troy Alexander following a report that a brutal sexual assault had taken place. The officers pushed their way into the residence, seized it for 12.5 hours before seeking a warrant, and had Alexander's cars towed. The next day, after obtaining and executing a warrant, they found narcotics and drug paraphernalia in Alexander's bedroom. The city of Syracuse then brought several waves of criminal charges against Alexander, which prompted multiple arraignments. In the midst of these proceedings, Alexander contends defendants improperly delayed Alexander's pretrial release on 2 occasions. For less than a day after Alexander first posted bail, and for 4 days after he posted bail a second time. Holy shit. At the end of this event, the city and county dropped all their charges against Alexander. Shit. Asserting rights under the U.S. Constitution, he sued the city, county, and detectives. Wow. So that's how bad they screwed up. They screwed up so bad that they dropped all the charges against him. Damn, man. On Monday, October 24th of 2016, a Syracuse hospital contacted police to report a patient had been sexually assaulted. Two officers, Detective Thomas Lund and Officer Dustin Kellich, received the call at 3:59 p.m. and went to the hospital. After speaking with LM, the victim, the officers learned that LM was a 19-year-old who lived in the house. They also learned that LM occasionally engaged in sex work, and she's an occasional prostitute, and she allegedly paid Alexander so she could use one of the rooms for her escort services. Lol. LM also said that Alexander sold cocaine from the home. Although LM was lethargic and drowsy, she's able to relay what she could remember from the previous day. She began explaining that her friend Samantha lived in a room in Alexander's house. He's got a little harem going. The day before LM and Samantha went to Samantha's room to get money, they did so. LM tried to leave the premises. However, two women, SB and LB, obstructed her path and forced her into the basement. LM was then blindfolded, tied to a bench, and had her lips super glued together. Yikes. The assailants stripped LM naked, burned her with cigarettes, and injected her with more than 10 times what LM believes to be drugs. Thereafter, an unknown man raped her. Wow. After the attack, SW and LB cleaned LM and threatened her. Two said if LM spoke to the police about what happened, they would kill her. The captors released LM. Other than these specifics, LM was unable to recall additional details. Well, that all sounds really, really bad. That all sounds really, really bad. And the police fucked this up so bad that a person who did horrendous things is going to get away with it. And they're going to be able to sue the police for violating their rights. That's how bad it got screwed up. Way to go, police. Way to absolutely go. The victim gets no justice, and the bad guy is going to be able to sue the police. That is just stellar work. Erin Cullen, the friend who accompanied LM to the hospital, supplied some additional context. She explained the day before while LM was at Alexander's house, Cullen was spending the night at LM's residence to take care of someone else who lived there. At 4:45 in the morning, Cullen saw LM come home and was completely naked. LM also appeared highly intoxicated and bled heavily from her groin. Concerned, Cullen said she waited to call the police, or she wanted to call the police, but LM dissuaded her and went to bed. When LM woke up, Cullen convinced her to go to the hospital. Consistent with LM and Cullen's narratives, Detective Lund saw peeled skin on LM's lips, as well as abrasions, scratch marks, burn marks, and needle marks on her body. Yeah, that sounds like some evidence that some sort of assault happened. It's like, oh, my lips were super glued together. Oh, yeah, I can see the things on your lips. Oh, I was injected 10 times. Yeah, I can see the needle marks. I was burned with cigarettes. Oh, I can see the burn marks. Yeah, okay, our prima facie that this woman has been assaulted and sexually abused is looking reasonably solid right about now. You know, just do it right, man. Just do it right. Damn. Can she file a civil suit against him? Yes, she can sue him too. She can sue him too. That's fine. So everyone gets to sue everyone, but no one goes to jail. A doctor also relayed that an X-ray image depicted a razor blade lodged in LM's anal cavity. Well, that's not good. Razor blades don't go on the anus, I'm pretty sure. Further corroborating LM's story, Cullen brought LM's bloody underwear to the hospital. With this information in hand, Detective Lund contacted the criminal investigation to take further action. At around 5 p.m., two more officers arrived. The newly arrived officers remained there, and Detective Lund left for the house. It sounds to me like what you should probably do at this point is get an arrest warrant. And also a search warrant. Sounds to me like what you should probably do at this point. That would be, I think you've got your prima facie. You've got one witness, you've got physical evidence, you've got someone else who brought her to the hospital who's saying things. It's like, I think you've got your prima facie. I think your next step here is an arrest warrant and a search warrant. Just saying. But we didn't do that for some reason. All right, Alexander owned the house where LM alleged assault occurred and lived there with 5 people, 3 relatives, his mother, father, and brother. His mother and father are also part of the prostitution house? Holy shit. His mother and father are also part of the prostitution house? Wow. The family that prostitutes, the family that pimps together, stays together? Holy shit. And 2 non-relatives. After Detective Lund contacted CID, Detective Gilloy was sent to Alexander's house to act as lead investigator. By 6:50 p.m., Detective Gilloy arrived at the house, and Detective Lund briefly recapped for him what they conveyed at the hospital. The 2 detectives and others then knocked on the door. A health guest entered. The parties didn't dispute it. Why didn't you get an arrest warrant and search warrant? Or just a search warrant. I think a judge would have signed off on a search warrant. You know, what do I want to search for? Well, I want to search for the needles. I want to search for any bloody clothes. I want to search for the cigarettes, burnt cigarettes. You know, they might have DNA on them. And, you know, other elements that relate to the crime. $5 from Rosemary J. Love the way you interact with Chad in your legal analysis. Yeah, I don't know why they didn't just get a search warrant. I would have signed off on that search warrant. Okay, you want to search, let me make sure I understand. You want to search for the needles. You want to search for the cigarettes because maybe they have DNA on them. You want to search for the bloody clothes. And you want to search for anything else that might establish the elements of the crime. Great, cool, go forth, no problem. Yeah, no problem. You've got your prima facie, go forth, my son. What judge wouldn't sign off on this search warrant? I mean, come on, give me a break. Yeah, and what evidence do you have of this? What evidence do you have that any of these things occurred? Well, we have the victim who says it occurred, and what else? Oh, we have the needle marks, and we have burnt marks, and you know, we have the bloody underwear and stuff. It's like, oh, okay. Yeah, that sounds like our prima facie to me. Sounds good. You want me to help? Damn. According to Detective Gilloy, the house guys gave him permission to enter, but according to the house guys, as officers pushed their way in. Brother testified the officers then went upstairs with their gun out. Just get the warrant, damn it. During the ensuing sweep, officers wrecked a room belonging to the father, rummaged through a dresser, and dumping personal belongings onto a bed. Why? Why are you doing a search without a search warrant, man? Why? Why not just get the warrant? Do you not know how to get a warrant? When officers encountered Alexander, they found him sitting on a toilet. They told him to get upstairs and go downstairs. Once every occupant had gathered in the living room, Alexander told the police to get out of his house and get a warrant. The officers responded by surrounding the group in a horseshoe formation. By 8 p.m., they were escorting Alexander out of the home. They were forced to leave cell phones, wallets, and others belonging outside. You're arresting the guy inside his own house. You can't really do that. You know, you can't, even if you have probable cause to arrest, you can't arrest the guy in his own house without an arrest warrant. You can wait till he gets out on the street, wait till he gets in a car, then arrest him. But you can't arrest him from his house without an arrest warrant. If you wanted to arrest him, just get the arrest warrant. Just go get it. Go get it. Like a normal person. Then you can arrest him. I think the judge would have signed off on the arrest warrant. I'm just saying. You could have gotten your arrest and search warrant, man. Damn. All right, the precise timing is unclear, but sometimes before Alexander and his group were forced outside, Detective Gilley had already gone outside. He saw 3 cars, one covered and 2 uncovered. They shined his flashlight in 2 uncovered cars and saw each of them red spots that appeared to be blood. Go get a warrant. To preserve this potentially incriminating evidence, Detective Gilley had the 2 cars towed. Although the parties did not submit a visual depiction of the driveway, testified that tow cars were properly in first side inside the house. From this description, it appears a wide driveway space lay in front of the house. Alexander does not appear to dispute this description, describing it as a parking lot. Makes sense. Based on this description, it seems like several people had access to it. Yeah, so that too. How did you know just get a warrant? In total, they seized the house for 20 hours. During the period 12.5 hours, it passed between the initial seizure and the submission of the warrant. First, while they towed the cars, the detective told Alexander, "This is what happens when you piss me off." Oh, it's not because I did it because of the evidence. I did it because you made me mad. Okay. Second, shortly before 10:43 p.m., an officer went inside Alexander's home, heard noise. The officers following the disturbance and found Teresa Duff, Alexander's cousin, trying to escape through the window. The officers apprehended her, and Duff wrote a sworn statement which she stated Alexander told her to get in the house and get a cell phone. Third, the seizure of the house forced Alexander and other occupants to spend the night outside or find other arrangement. Stay warm, Alexander's others stayed by a fire pit. Throughout the night, while Alexander's and others waited outside, officers changed shifts. At 5:45 a.m., Alexander left where he could go to work. What is his job? I want to know when he's not pimping. That's also something I want to know. I'm gonna go to work today. Lol. Fourth, after Detective Gilley left the premises and after Alexander's car was towed, Detective Gilley returned to the office and drafted the warrant. Armed with a warrant, we left the house and arrived. They got back to work. As he approached the house, he saw dump a pot of water on his family fire pit while arguing with the sister. Angered, Alexander said that's it and walked towards a nearby corner store to get video footage of the preceding events. Oh, from the store, presumably. I was confused. When they did so, they arrested him on some charges. They finally executed the search warrant. Yeah, at 4 p.m., they finally executed the search warrant. It's unclear why it took so long since they had the warrant at 11. Some 30 minutes later, the officers complete the search and they seized a beige, chunky substance, 3 scales with white residue, a bottle of a cutting agent, hundreds of small plastic bags, and personal papers. The items were all found in the bedroom. A field sobriety test on the substance yielded cocaine. Holy shit. And then a somewhat complicated series of formal criminal proceedings thus followed. I bet they are complicated. Yeah, so then for whatever combination of reasons, and then we're going to get into whether you detained me too long after I post bail, which I'm going to kind of skip that issue for the moment. And at some point, the state dropped all the charges, presumably because of their massive fuck-ups. So, and now we're going to sue for violating my rights because we went into your house and seized it without a warrant, and didn't you let you out? So now we're going to sue for my inconvenience. How dumb was this? Where was this? Syracuse, New York. That's dumb. Body cams, can you say redactions? I don't know if there's any body cams. It doesn't really matter for the purposes of this particular analysis, so the court didn't discuss it. Like what happened on the body cams and stuff. This is the civil proceedings, so they didn't necessarily go into all the details, but yeah. Ninth Circuit had an en banc decision upholding California's ban on large capacity magazines. Not surprising. Let's see what else. Does the district court have power to order an intervener to return or destroy confidential documents since they're parties? Yes. Fair enough. What else? Can Florida ban those from under 21 purchasing firearms? 11th Circuit, yes. But that differs from the 3rd, 5th, and 8th Circuit. So the issue of can you ban 21-year-old from purchasing firearms may yet wind its way up at the Supreme Court. That sounds like a case the Supreme Court might actually take up. They probably are not likely to take up the mag ban case, but they might take up the 21-year-old case. That sounds plausible. So that might be happening. Okay, so that's all cool. And then what else? In federal appellate land. All right. A Myrtle Beach, South Carolina bar owner challenges a municipal violation that restricts broadcasting of obscene, profane, or vulgar language from a commercial property above certain volumes at certain times. The district court upheld the ordinance, concluding that vulgar language prohibition applies only to speech that is constitutionally obscene. The 4th Circuit, that ruling is binding on state courts and doesn't make any sense. This is good. North Carolina man pleads guilty to being a felon in possession of a firearm with a guideline sentence range of 41 to 51 months. He's a felon in possession. Guideline is 41 to 51 months. He's sentenced to 114 months. The Fourth Circuit says unreasonable. Dissent says, well, he did do an awful lot of stabbing while he was in pretrial detention. That's unreasonable. But what about the stabbings he also did? Law. Okay, this is interesting. I might cover this. University of Illinois Chicago law professor has long given a civil procedure exam with a question about discrimination involving a racial slur. Which makes sense, right? Because and he actually puts the slur on the exam because we have to talk about what we're talking about, right? It's like, okay, this person is discriminated against and there's a racial slur involved. And so I'm going to put the racial slur on the exam because we all need to know what we're talking about. Right? Right. Okay, great. Moving on. And he's been doing this for a long time. So this isn't like a new thing. He's been doing this. This has long been a thing he's been doing. All right. But when students complained in 2020, the university hunts through everything he's ever said in class for anything that could be seen to be offensive to justify disciplining him. The question, is it First Amendment retaliation? The state university professors don't have free speech rights. They're just mouthpieces for the government. Not an invalid argument. Not an invalid argument. The Seventh Circuit, no. To impose any straitjacket on intellectual leaders or colleges and universities would imperil the future of our nation. Interesting. Yeah, so the idea that they're just mouthpieces for the government is not necessarily an invalid concept, but it is relevant that it's a university professor versus K through 12, because there does seem to be a split here on some of this issue when it relates to some of this. So we'll get to sort of the punchline on this thing. Okay, so actually it doesn't even use the word. It doesn't even use the word. So he literally wrote, for the past decade, he's included the same question on the final exam. The question concerns a fictional former employee. This is a law school exam, right? The question concerns a fictional former employee who said he quit her job at the employer after she attended a meeting in which another manager expressed anguish with the plaintiff, calling them N underline and B underline, and vowed to get rid of her. The exam questions appear exactly like this, with the racial and gender slurs expurgated. So he didn't even include the words on the exam, which he probably should have done, but he didn't. He just said N underline and B underline, but he didn't even include the words. All right. Unlike in prior years, students who took the exam in December 2020 were upset by the use of these slurs. Well, how am I supposed to ask the question without at least referring to them? Right? It's like, that's the question. Like, how do I ask the question without even doing that? Right? In response, Kilborn reached out to students to discuss the exam question. He sent a note of regrets for any distress, exchanged emails with students about the incident, and participated in a cordial, constructive 4-hour Zoom meeting with the Black Law Students Association. Oh, he did the struggle session. He did the struggle session. Never do the struggle session, guys. That's a mistake. Never do the mistake. During the Zoom meeting, a member asked him why the dean had not shown him a student petition critical of the exam question. He replied perhaps the dean had not shared the petition with him because she feared he might become homicidal if he read it. Lol. He made the comment in jest, and the conversation continued for another hour. However, students later told the dean they felt that being homicidal, he said he felt homicidal or would become homicidal. Asserting they feared a possible threat of imminent violence, they placed him on leave. Holy shit. He was ultimately released, but only after submitting to a drug test. His classes remained canceled. The university's response to the controversial exam did not end there. It opened an inquiry into his allegedly racial hostile environment. Holy shit. Some of our schools are woke. This is a law school, people. This is a law school. How woke can we be? Apparently all the woke is the answer. Damn. As part of the investigation, University reviewed comments Kilbourne had made in class 2 semesters earlier. There, Kilbourne had discussed relationship between frivolous litigation and media coverage. And apparently, there is a quote. So someone has this on video, I guess. Apparently, he 2 years ago had said this: the fact that other plaintiffs see that the other plaintiff loss isn't a disincentive. If it were, frivolous litigation would have ended long ago because lots of plaintiffs have been pushed to the wall and lost. You don't hear about those stories in the media. You hear about idiot people winning $1 million verdict against Subway for having 11.5 inch long sandwiches. That's what makes the press, right? The Subway lost, not that they win against this ridiculously frivolous case. That wasn't in the media, only illegal media, maybe if you're paying attention. And that's the problem. If they win, no one hears about it. They only win if they lose, and God forbid that, then they're all cockroaches coming out of the wall. They're thinking, right? Apparently that was the wrong thing. In the same discussion, Kilbourne also remarked, I'm not subjecting my corporate bottom line to that public lynching. I'm sorry, that's not the right word to use. It's a perfectly valid word to use. Geez, how we all understand you mean lynching metaphorically, or we should all understand that we're law school, right? How dumb are we, right? Damn. At the end of the investigation, University concluded Kilbourne violated harassment aspect of its non-discrimination policy. University based its finding on the use of the examined question, out-of-class conversation with students, and something about cockroaches and lynching, and use of the AAVE accent. Holy shit. Specifically found Kilbourne's out-of-class comments express insensitivity and hostility. He received 2 punishments. The university declared him ineligible for across-the-board 2% merit rate and required him to participate in an 8-week diversity training program. Holy shit. The course include coursework, self-reflection, and meeting with the trainer to provide feedback. He couldn't return until he provided satisfactory completion. Kilbourne has repeatedly asked university officials what he should have done differently to avoid violating non-discrimination, but alleges they never told him so. Although the policy does not include a definition of harassment, university officials understand scope to be broader than the law. As a result, Kilbourne fears the university may enforce a policy against him again. Kilbourne sued officials. Okay. Public employees do not relinquish First Amendment rights as a condition of in government service. Typically, that's correct. But when the government interest is regulating speeches, like private employers, to balance the competing interests. But this is in the context of his employment, so that makes things more challenging. Like, this is specifically him as an employer, and it's in an educational facility. Yeah, I don't know about this on the law. Okay, first we must determine whether speaking on a matter of public concern. And the Supreme Court clarified public employees are not speaking as citizens when they make statements pursuant to their official duties. That makes sense, right? Because you're in your official capacity, so you're not a person, you're the official. We consider whether the rule applies to Kilbourne's speech before applying the public concern. So the exam question in class remarks fall within teaching responsibility, which it clearly does. The Supreme Court has made clear its decisions not extend to cases involving speech-related scholarship or teaching. Instead, reserve that question in response to Justice Souter's concerned decision would otherwise imperil First Amendment protection. As the court has recognized, expression relating academic scholarship implicates additional constitutional considerations that could have important ramifications. So again, this also, to some extent, again, there would be a difference between K through 12 and university. So I don't necessarily think this would necessarily be true in a K through 12 environment. And whether or not it should be true even in a university environment, I think is a fair question, to be quite honest. Because he's the official, right? But, and it's dumb. It's dumb. In singling out the public university setting, universities apply special niche. Yeah. So the fact that it's university as opposed to K through 12 or some other environment does matter. Whether it should matter, but it does matter. If, for example, in Kirshen versus Board of Regents, court recognized academic freedom as special concern and as transcendent value. Yeah, fair enough. We declined the university's officials to extend the speech involving university teaching and scholarship when the Supreme Court was unwilling to do so. Every other circuit decided this issue is decided does not apply. So the Supreme Court didn't necessarily foreclose the issue, but every court that's done this has said no. It's like the Supreme Court isn't going to say it. We're not going to say it. All right, we're not going to extend this logic. So fair enough. Fair enough. I must be feeling great. I'm feeling pretty good today. I'm feeling positive and in reasonably good spirits today. I'm not frustrated. I'm not beating my head against the wall of chat or something. I'm feeling reasonably positive today. Things are a good day. If we string enough good days together, man, maybe the depression will just go away forever. Who knows? One can always hope. For similar reasons, universities are not entitled to qualified immunity. Before Garcetti, it was clearly established that the test offered qualified protection of public employees, including professors. Fair. We do not suggest reliance on Garcetti would never be appropriate to support qualified immunity. In some cases, it might be, yeah, blah. Next, we turn on public concern analysis. This category of speech is not limited to matters transcendent important, but matters the public might be interested in. Yeah, applying standard district court held not if the speech addressed a matter of public concern. It found that the exam question could not contribute because only Kilbourne students would read it. Kilbourne's out-of-class remarks were directed at individual students and concerned only his personal reaction, and Kilbourne's in-class statements would not form broader debate. That doesn't make any sense. First, it didn't give adequate weight to the academic setting. In this setting, speech may not inform broader public discourse because it's directed narrowly at students, but doesn't detract from its public importance. And the university is a peculiarly marketplace of ideas. Yeah. Our case law reflects the public importance of academic speech, even where it's narrowly tailored. Yeah, we do not mean to suggest university professors address it whenever it directs to students. Yeah, I have no problem with this, given the state of the case law. Yeah, they're all academic speech that address matters of public concern. The exam was designed to give students an experience confronting a highly charged situation they may encounter in real life. Yeah, sometimes the law is not necessarily a nice place. Did you guys know that? Did you know that sometimes actual cases involve racial slurs and stuff? Did you know that? It's like if you're that sensitive, you're going to have a bit of a problem as a lawyer. You know? How eggshell are you, man? The relevant question is not whether the speech fell short of refined social or political commentary, but the issue is trying to highlight matters of public import. The dominant themes of the class concern pretextual police stops and relationship between frivolous litigation, plaintiff incentives, and media coverage. These are undeniably matters of public concerns. Kilbourne's references to cockroach and lynching and use of the AAVE accent may be insensitive, but they don't affect the quality of the speech. The university may disagree with the approach or think the statements fall short of refined commentary, but that's not something we consider. Yeah, I have no problem with this. This is fine. All right, guys, I think I'm going to bring this stream to a conclusion. And I've had a lot of fun. And I don't anticipate that we're going to have any more of Karen Reed until the trial starts, which probably is going to be 2 weeks, if I had to guess, especially if we're doing individual voir dire of individual jurors. It's going to take a long time, right? Because we have to find a non-biased jury, which I think is definitely possible because there's a lot of people that live here. But of course, since the exposure, more people have been exposed. So if we're going to do this one at a time, it's going to take a hot minute. So yeah, so probably 2 weeks for jury selection is probably a very realistic time frame. So yeah, anything else before I sort of wrap the stream up? And then I go have lunch with Nate. And I tell him about the watches I saw yesterday and stuff. Let me ask your opinion on a watch, because I don't know how I feel, and I don't know that you will necessarily. Well, I know that. Not sure that you can tell me how I feel, but I don't know. Like these Grand Seikos are interesting, but you know, like what was the one I was looking at earlier? I was looking at like this one here. Is this the snowflake? Yeah. All right. I don't want to get the snowflake because everyone has the snowflake. Yeah. Something like this. I mean, it's simple. It's clean. I could do without the spring drive marker on the face, to be honest. They do make ones without the spring drive marker, but they're way more expensive. They're like twice as expensive, you know, to get it without the marker. But I mean, it's nice. It's dressy. It's very shiny. But I don't know. I think maybe it's just a little cold. It's $5,000. So yeah, it's too bland. Yeah. Yeah, I hear you. I hear you. It's too bland. Yeah, yikes indeed. I mean, well, to be fair though to the watch, it is like the attention to detail is insane. It's Grand Seiko, and their attention to detail is absolutely ludicrous. So they use the best materials, and they do everything like by hand, and they're like the quality is like off the chart. It's off the charts in terms of like what they provide. So it's very expensive, but you know, you can actually sort of justify it based on like what's there, right? It's like, oh, it's all done by hand. It's all polished to perfection and everything is done. And it's a very exacting Japanese way to this utter perfection of, you know, everything. So it's expensive, but there's a lot in the watch. There's a lot in the watch. So to be fair. And that's the cheap ones. It gets more expensive from there. But yeah, sticking with your calculator watch, I feel that too. That's perfectly fair. I respect that. All right, guys. Well, I think I'm going to go ahead and sign off for now, and we'll talk more. I was like, does it let you control time? Yeah. Yeah, fair enough. Does it let you control time? I appreciate that. No, not really. No. And you know, so it's like, what are you paying for? I suppose it's like, what problem are you trying to solve? I don't know. That's a fair point. All right, guys. I love you. I'll talk to you guys later. All right. Bye-bye for now. Cheers. Yeah. Grand Seiko is not the same level as Seiko, more like Rolex. Yes, exactly. So yes, 100%. Yeah. Grand Seiko is way better than Seiko in terms of their quality. Yeah. It's on par with Rolex and arguably better than Rolex, not for least reasons that you cannot actually buy one. And buying a Rolex sometimes is really challenging. So, yeah. So, yeah, they're definitely in the same conversation as Rolex, for sure, or Omega, yeah. All right, bye-bye. Just get a Hamilton? Maybe. I mean, the Murph is pretty cool. That's for sure. In 42 millimeter, I need the 42 millimeter because I need the size. But yeah, the Murph is a pretty good do anything watch.